Candy Louise Martin was shot dead on February 16, 2001, in Dorchester County, South Carolina, by a high school friend who threw her body in the trunk and set the car on fire, burning her body in the process. Marion Bauman Jr., the murderer, was taken into custody and accused of both murder and arson. Bauman, who killed Martin due to a financial argument, was convicted on both counts and given a death sentence for Martin's murder and a 10-year prison sentence for third-degree arson. Bauman, who had subsequently exhausted his appeals against the capital penalty, was killed by lethal injection on January 31, 2025, while he was incarcerated at Broad River Correctional Institution on death row. The body of 21-year-old Candy Louise Martin was discovered in the trunk of her car in Dorchester County, South Carolina on February 17, 2001. Court sources say that 20-year-old Marion Bauman Jr. was with his sister the previous day when he ran into Martin and her companions. According to reports, Bauman wanted to speak with Martin, a high school friend, so he requested his sister to stop the car. Bauman's sister claims that after asking Martin to give him back some cash, and Martin instructed him to wait until she had finished speaking, Bauman responded with, "That bitch be dead by dark." Bauman and his buddies had been partying at a residence that evening when Martin pulled up. Bauman got into her car with his cousin, James Taiwan Gadsden, and all of them drove to a distant location that Bauman had indicated. As they exited the vehicle, Gadsden claimed to have heard Bauman inform him that he wanted to kill Martin. Bauman then pulled out a revolver and fired 3 bullets while following Martin. According to reports, Martin hurried forward to confront Bauman and begged him to spare her life because she had a child to take care of. Bauman fired his gun twice and killed Martin despite her cries for mercy. Then he dragged her body into the bushes around it. Bauman drove Martin's car back to town after threatening Gadsden to keep the fact that he killed Martin a secret, even though he himself boasted about it to others, including Hiram Johnson. After failing to sell the car at the club, he spent the evening driving the vehicle around with other people. Bauman then asked another friend, Travis Felder, to assist him in returning the vehicle to the scene of the murder. Bauman parked the vehicle, then took Martin's body from a nearby bush and stuffed it into the trunk before setting the vehicle on fire. He admitted to Felder that he killed Martin while setting the car on fire. Both men then left the scene. Firefighters discovered Martin's burnt remains after responding to a complaint of a burning car at approximately 3:54 a.m. on February 17, 2001. After Bauman's DNA was discovered in Martin's private area, the police were able to connect him to the murder that same day in the afternoon, and they detained him as a suspect. Dorothy, Bauman's wife, discovered his firearm at home, and the next day an unidentified family member dumped it into the Edisto River from a bridge. Law enforcement later recovered it and identified it as the gun used in the murder. A grand jury formally indicted Marion Bauman Jr. in June 2001 on 1 count of murder and 1 count of third-degree arson. Bauman was put on trial before a jury on May 17, 2002. Walter Bailey led the prosecution. During the trial, Marva Hardy Thomas and Norbert Cummings Jr. represented Bauman. In addition to claiming that the gun might have been planted by investigators to further implicate Bauman as the murderer, the defense contended that Gadsden's testimony should not be believed because he and the other parties in the case had accepted plea deals and had a justification for identifying Bauman as the shooter. After 3 hours of discussion, the jury found Bauman guilty on both charges of murder and arson on May 24, 2002. Citing mitigating evidence that Bauman was raised in a chaotic household with a history of serious alcoholism in his mother's family, and that he started drinking alcohol at the age of 10 and even traded narcotics at the age of 14, the defense requested life in prison for Bauman. However, given the seriousness of the offenses and the aggravating circumstances, the prosecution requested the death punishment. The jury unanimously recommended the death penalty for the murder accusation, and Bauman was condemned to death on the same day of his verdict. Bauman was also found guilty of arson and given a 10-year prison sentence. Following their plea deals with the prosecution, Travis Felder and James Gadsden were also given reduced charges in court over Martin's murder. Gadsden received a 20-year prison term for both wrongdoing of a felony and accessory after the fact of murder, while Felder received a sentence of 3 years in prison, which was later changed to 3 years of probation. Marion Bauman challenged his death sentence to the South Carolina Supreme Court after receiving it. The Supreme Court denied Bauman's direct appeal on November 28, 2005. Bauman's second appeal was denied by the South Carolina Supreme Court on January 10, 2018, and his conviction and death sentence were maintained on March 26, 2010, when U.S. District Judge Terry L. Wooten of the U.S. District Court for the District of South Carolina denied his appeal. Bauman's appeal against the death penalty was denied by the Fourth Circuit Court of Appeals on August 16, 2022. His death sentence was ultimately upheld by the U.S. Supreme Court, which denied his last appeal. Marion Bauman's case attracted the attention of civil and anti-death penalty organizations while he was on death row. In addition to stepping up attempts to secure clemency for him, the American Civil Liberties Union had taken up Bauman's cause and conducted an interview with him while he was incarcerated in an attempt to increase awareness of his case and narrative. However, in order to prevent the possible loss of private information or system security breaches, inmates were prohibited from speaking to the media, including in-person media interviews, or having their work directly published in accordance with South Carolina prison regulations. As a result, Bauman's interview tape from the ACLU was forbidden from being aired in the media. In order to address this matter, the ACLU petitioned the federal courts to overturn the ban, arguing that it infringed upon the prisoner's First Amendment rights to free speech and might have protected the South Carolina Department of Corrections from actual public scrutiny regarding potential instances of inmate abuse. The action was dismissed by U.S. District Judge Jacqueline D. Austin on September 5, 2024. The judge maintained that the media did not have special access to sources that should not be made public, and that the state retained the ability to prevent them from doing so. Bauman was one of several death row inmates who filed a lawsuit against the state of South Carolina in 2023, arguing that the electric chair and firing squad were unconstitutional because they were cruel and unusual punishments that would cause the condemned unnecessary pain and suffering. However, the state's attorney retorted that the firing squad and electric chair both adhered to current procedures and that the law did not require that death be immediate or painless. At that time, the lack of lethal injection drugs, the expiration of the state's current drug supplies, and the refusal of several drug companies to sell their drugs to the state for executions resulted in an unofficial moratorium on executions in South Carolina since the state's last execution in 2011. The state government responded to this issue by reintroducing the electric chair and passing new legislation allowing firing squad execution as a backup method of execution in the event that lethal injection was not available. Finally, in September 2023, the state was able to acquire new medication to resume lethal injection execution. A 5-judge panel of the South Carolina Supreme Court rendered its final decision on July 31, 2024, affirming the constitutionality of both the firing squad and the electric chair. The majority of the judges approved the two methods, 4 for the electric chair and 3 for the firing squad. This ruling made it possible for all 32 of the state's death row convicts, including Bauman, to have their executions resumed in South Carolina. 5 condemned prisoners, Bauman, Freddie Eugene Owens, Richard Bernard Moore, Brad Sigmund, and Mikal Mahdi, had exhausted their appeals at the time of this decision and were most likely about to be executed. After one of the 5 prisoners, Freddie Owens, was executed on September 20, 2024, the 13-year moratorium on South Carolina was eventually concluded. Richard Moore was put to death on November 1, 2024, after Owens. Since Bauman was given a death sentence in 2002, it was anticipated that he would be the next condemned prisoner to be put to death. Since Moore was executed, it was assumed that Bauman would be put to death on December 6, 2024, 5 weeks later, and that a death warrant would be issued on November 8, 2024, a Friday, as the state frequently issued death warrants on Fridays. Nevertheless, that date was not the execution date. Bauman and the other 3 convicted prisoners on the execution schedule list reportedly appealed to the state on November 11, 2024, requesting that their executions be postponed until after Christmas and New Year's Day in order to avoid the winter holiday. The South Carolina Supreme Court agreed to give the prisoners a short reprieve on November 14, 2024, and to refrain from issuing any more death warrants until at least January 3, 2025. Bauman and the other 3 inmates on the death row had their possible execution dates rescheduled to 2025 as a result of this agreement. Bauman's death warrant was signed by the South Carolina Supreme Court on January 3, and his execution date was set for January 31, 2025. Bauman was sentenced to death by firing squad, lethal injection, or electric chair, and he was granted until January 17 to choose one of the 3 means of execution. He ended up choosing lethal injection. Bauman was close to Richard Moore, whom he saw as a father figure. Moore, who was executed back in November, taught Bauman to read and play chess, taught him coping mechanisms for the harsh conditions of prison, and encouraged him to avoid worrying about things that were out of his control while he was on death row. The family of Candy Martin responded to Bauman's planned execution by saying that, although they would not be present, they saw it as a measure of justice and closure following the loss of Martin 24 years prior. They said that Bauman had 24 years to continue to connect with his own family, including his daughter and granddaughter, from behind bars, and the family believed Bauman was indeed the real killer, dismissing his claims of innocence. Martin did not have the chance to spend time with her son and become a grandmother. Her son was just 2 years old when she was killed. Marion Bauman filed an appeal to overturn his conviction on the basis of prosecutorial misconduct on December 17, 2024, while his death warrant was still pending in court. Bauman argued that the prosecution's failure to reveal important evidence during his trial, such as the psychological issues and potential confession of one trial witness, as well as the criminal charges pending against another trial witness, hindered his right to a fair and impartial trial and effectively cast doubt on the legality of his conviction and sentence. Additionally, they claimed that Bauman's trial attorneys failed to appropriately defend Bauman, an African American, because they were showing sympathy for the victim, which was a white woman. Bauman also requested that his death sentence be reduced to life in prison without a possibility of parole. His attorney produced signed testimony from a number of former nurses and death row employees who characterized him as a kind giant who had a unique talent for helping mentally ill prisoners engage with psychologists and take their medications as prescribed. For many years, Bauman was the official point of contact between prison officials and death row convicts. Bauman acknowledged having relations with Martin and selling her narcotics in a public statement on January 2, 2025, but he insisted he didn't kill her. He requested on January 8, 2025, that his execution date be postponed until his appeal regarding the constitutional violations of his trial was concluded. His appeal was dismissed by the South Carolina Supreme Court on January 17. Bauman requested additional details regarding the pentobarbital used for fatal injection executions in South Carolina in a different appeal submitted on January 23. Citing Richard Bernard Moore's autopsy results, he voiced his worries that the lethal injection execution in his case would not proceed smoothly. According to the findings, Moore felt as like he was drowning and suffocating throughout the 23 minutes that led to his death, since fluid was discovered in his lungs. In addition, it was disclosed that Moore received 2 substantial doses of pentobarbital, separated by 11 minutes, and Bauman said he needed further details and explanation. The state prosecutors also noted that Bauman could not have chosen the firing squad or electric chair if he had been genuinely worried about the consequences of lethal injection, and an anesthesiologist said that it was typical to find fluid inside the lungs of executed prisoners, particularly those who received lethal injection. On January 28, U.S. District Judge Jacqueline Austin heard the appeal and dismissed it, ruling that Bauman was not entitled to more information about the drugs that would be used in his lethal injection execution. She also said that Bauman could still choose to be executed by firing squad or electric chair if he really had doubts about the effectiveness of the lethal injection drugs. The U.S. Supreme Court rejected his last appeal on January 30, 2025, the eve of his scheduled execution. Bauman, through his attorney, then declared that he would not ask South Carolina Governor Henry McMaster for clemency, saying he would prefer not to live out the rest of his days behind bars for a crime he insisted he never committed. Bauman's family, however, begged the governor for clemency, as he was the only one with the authority to commute his death sentence to life in prison if he agreed. The governor decided to not grant clemency. On January 31st, Bauman glanced at his lawyer across the glass in the witness room for a moment when the curtain to the death chamber opened, then turned back to the ceiling and closed his eyes. He looked up and opened his eyes once more. Bauman puffed his lips as he exhaled once his lawyer had done reading his final statement and poem, which lasted 3 minutes. Those gasps stopped less than a minute later. After 20 minutes, a stethoscope-wielding doctor put a hand on his neck and listened to his chest. Bauman noted in his closing remarks that although death row inmates may be known as the worst of the worst, they have all evolved and matured after their life-altering event. His last words were, "I know that Candy's family is in pain. They are justifiably angry. If my death brings them some relief and ability to focus on the good times and funny stories, then I guess it will have served the purpose. I hope they find peace." His last meal was fried seafood, including shrimp, fish, and oysters, chicken wings and tenders, onion rings, banana pudding, German chocolate cake, cranberry juice, and pineapple juice. These 4 men met their fate in the execution chamber. Their crimes were brutal. Let's uncover what really happened when the clock ran out, what were their last meals, and their last words. The first one to be executed was Stephen Nelson on February 5, 2025 in Texas. Stephen LaWayne Nelson, born February 18, 1987, was a murderer sentenced to death for the 2011 killing of Pastor Clinton Dobson in Arlington, Texas. On March 3, 2011, Nelson stormed into North Point Baptist Church, attacking Dobson and Church Secretary Judy Elliott during a robbery. Dobson was beaten and suffocated with a garbage bag, while Elliott was left severely injured but survived. Nelson stole their belongings, later using Elliott's credit cards for personal purchases. A police investigation linked Nelson to the crime through forensic evidence, including bloodstains on his shoes and fingerprints at the scene. He was arrested after failing to report to his probation officer. Despite his claims that 2 friends committed the murder while he acted as a lookout, the jury found him guilty of capital murder. He was sentenced to death on October 16, 2012. Nelson had a long history of violent crime, beginning in childhood with burglaries, assaults, and property offenses. He spent years in juvenile detention and later faced multiple arrests for theft, assault, and probation violations. While awaiting trial for Dobson's murder, he was accused of killing fellow inmate Jonathan Holden by strangulation. Nelson's appeals were repeatedly denied, and his execution date was set for February 5, 2025. His case has sparked debate among Christian leaders and death penalty opponents, though many, including Dobson's church members, supported his execution. Stephen LaWayne Nelson, 37, was executed by lethal injection and pronounced dead at 6:50 p.m. at the state penitentiary in Huntsville. Just before the injection was administered, Nelson repeatedly expressed his love and gratitude to his wife, who observed through a window nearby. "It is what it is," he remarked, and urged her to enjoy life. She responded by holding up a white service dog, which she was permitted to bring into the witness area. "I'm not scared, I'm at peace," Nelson said. "Let's ride, Warden." As the lethal dose of pentobarbital began, he told his wife, Helen Noah Dubois, whom he married while incarcerated, "Let me go to sleep." After the drug took effect, he uttered the word love, then gasped twice and appeared to try to hold his breath. His head, shoulders, and arms trembled briefly before all movement ceased. He was officially declared dead 24 minutes later. Texas does not offer special last meal requests anymore. Nelson simply had to choose something to eat from a menu that all other inmates had for that day. Just 1 day later, the second man executed was Demetrius Frazier, February 6, 2025, in Alabama. Demetrius Terrence Frazier was a serial rapist and convicted murderer on death row in Alabama for the 1991 rape and murder of Pauline Brown, a 40-year-old woman he killed during a robbery. He was also convicted in Michigan for the 1992 murder of 14-year-old Crystal Kendrick, whom he shot while attempting to assault her. In addition to these murders, Frazier was accused of raping 8 women in Michigan, with a jury convicting him of 2 assaults. Arrested in Detroit for Kendrick's murder, he later confessed himself to killing Brown. Frazier received 2 life sentences in Michigan in 1993 for Kendrick's murder and other crimes. In 1996, Alabama sentenced him to death for Brown's murder. He spent 18 years in Michigan's Alger Correctional Facility before being transferred to Alabama's Holman Correctional Facility in 2011. Scheduled for execution by nitrogen hypoxia on February 6, 2025, Frazier attempted legal appeals, arguing that the method was inhumane. A federal judge denied his request to halt the execution. His mother also pleaded for his transfer back to Michigan, but her request was denied as well. Demetrius Frazier, 52, was pronounced dead at 6:36 p.m. at a South Alabama prison, and the method of execution was nitrogen hypoxia. His last words were, "First of all, I want to apologize to the family and friends of Pauline Brown. What happened to Pauline Brown should have never happened. I love everybody on death row. Detroit strong." In his final words, Frazier also criticized Michigan Governor Gretchen Whitmer for not intervening after appeals for him to be returned to serve out a previous life sentence in Michigan. Strapped to a gurney with a blue-rimmed gas mask covering his face, the execution began around 6:10 p.m. following a final check of the mask by a corrections officer. For the first minute or two, Frazier moved his outstretched palms in a circular motion. At 6:12 p.m., he stopped moving his hands, appeared to grimace, and took a gasping breath. A minute later, he lifted both legs a few inches off the gurney before lowering them. His breathing slowed to irregular breaths by 6:14 p.m., and by 6:21 p.m., there was no visible movement. The curtains to the execution chamber were closed at 6:29 p.m. Alabama Corrections Commissioner John Hamm later stated that the gas flowed for approximately 18 minutes and instruments showed Frazier had no heartbeat 13 minutes after the gas started. Hamm believed Frazier lost consciousness quickly and that the subsequent movements, including raising his legs and sporadic breaths, were involuntary. In the hours leading up to his execution, Frazier spent time with his mother, sister, and legal team. For his final meal, he chose Taco Bell, which included burritos and a Mountain Dew. Real quick, before we continue, please subscribe to the channel. It will help me a lot since this will become my main source of income starting April. We've got 19 cats, 2 dogs, 2 hedgehogs, and a bunny that need food. I appreciate you all. Thank you for being here. Let's move on. The third person executed was James Ford on February 13, 2025 in Florida. James Dennis Ford was a convicted murderer and death row inmate in Florida, sentenced for the 1997 double murder of Gregory and Kimberly Melnery in Charlotte County, Florida. On April 6, 1997, Ford, Greg's co-worker, lured the Melnerys to a sod farm under the pretense of a fishing trip. Once there, he shot Greg in the head, slashed his throat, and bludgeoned him. Kimberly attempted to secure their 22-month-old daughter Miranda in the truck before Ford overtook, raped, and brutally killed her. He abandoned the child, who was later found alive but dehydrated and covered in insect bites after 18 hours alone. Ford was arrested on April 17, 1997, and convicted on March 8, 1999 of 2 counts of first-degree murder, child abuse, and sexual battery. Despite his defense arguing diminished responsibility due to drug and alcohol use, a jury recommended the death penalty by an 11-1 vote. He was sentenced to death on June 3, 1999, alongside additional prison terms for the sexual battery and child abuse charges. Over the years, Ford's appeals were repeatedly denied, including by the Florida Supreme Court and the U.S. Supreme Court. On January 10, 2025, Governor Ron DeSantis signed his execution warrant, and Ford was scheduled to be executed on February 13. Ford, 64, was executed by lethal injection at the Florida State Prison in Rayford and was pronounced dead at 6:19 p.m. This marked the first execution in Florida in 2025 and the fourth in the U.S. this year. His execution took place less than an hour before Texas was scheduled to execute Richard Lee Tabler at 7 p.m. for the 2004 double murder of two men. Officials reported that Ford did not speak any final words to those present at the execution, but did leave a written statement. His statement read, "Hugs, prayers, love. God bless everyone." For his last meal, Ford had steak, macaroni and cheese, fried okra, sweet potato, pumpkin pie, and sweet tea. 3 family members visited him on Thursday morning. As the injection began, Ford's chest began to heave, and then all movement gradually stopped. A few minutes later, a staff member shook him and shouted, "Ford, Ford." This was to check if he was still conscious, but there was no response. Moving over to Texas, in the same day, Richard Tabler was executed. He was born on February 5, 1979, and he was a spree killer convicted of 4 murders in Killeen, Texas in 2004. On November 26, Tabler and accomplice Timothy Doan Payne killed nightclub manager Mohammed Amin Rahmouni and his associate Haitham Frank Zayed over a dispute. 2 days later, Tabler murdered 2 teenage dancers from the same club, Amanda Benefield and Tiffany Dodson, fearing they knew about the prior killings. Tabler was sentenced to death for the first 2 murders, while Payne received life in prison. Tabler had a troubled upbringing marked by parental neglect, academic struggles, and an ADHD diagnosis. He had prior convictions for burglary, assault, and escape attempts. After his arrest for the 2004 killings, he initially confessed but later retracted it. His appeals spanned nearly 2 decades, with multiple attempts to waive them, though courts questioned his mental competence. His final appeal was denied by the U.S. Supreme Court on October 7, 2024. While incarcerated, Tabler illegally obtained a cell phone, using it to threaten Texas State Senator John Whitmire, leading to a lockdown and his mother's arrest for smuggling contraband. He was sentenced to an additional 10 years for these offenses. Tabler was scheduled for execution on February 13. Texas executed 46-year-old Richard Lee Tabler with a lethal injection of pentobarbital in the presence of his mother and sister among the witnesses. He was pronounced dead at 6:38 p.m., and in his final statement, Tabler expressed regret, saying, "There is not a day that goes by that I don't regret my actions." He directly addressed the victims' families, saying, "I had no right to take your loved ones from you. I am deeply sorry." His statement continued, offering words for the victims' families, saying, "If you feel that this is what you need to get closure, I pray it helps you find that." He also expressed hope for forgiveness, saying, "I just hope that one day you find that forgiveness to forgive me for taking your loved ones from you." Tabler thanked several prison staff members by name for their compassion and support, saying, "Your love and support have allowed me the opportunity to change and become a better man and rehabilitate." He reassured his loved ones, lawyers, and supporters, saying, "This isn't the end. This is only the beginning." He then thanked God, saying, "I thank God for allowing me to seek him out and finding him, showing that this isn't about me. We are all here today because of my actions, but in the end, it comes down to God, praising him and giving honor to him. I know this will be the end of this life, but it will be the beginning of my ultimate life in heaven." As the lethal drugs began to take effect, he said, "I'm sorry," one more time before his breathing became rapid. After several breaths, all movement ceased. Brad Keith Sigmund, March 7, South Carolina. On April 27, 2001, a week after splitting with his ex-girlfriend, Sigmund used a baseball bat to bludgeon David and Gladys Lark, ages 62 and 59 respectively, to death. They were the parents of his ex-girlfriend. The South Carolina Supreme Court issued Sigmund's death warrant on February 7, 2025, and set March 7, 2025 as the day of his execution. The court allowed him until February 21 to decide whether he wanted to be executed by firing squad, electrocution, or lethal injection. The electric chair would be selected automatically if he refused to select the technique. To the surprise of everyone, he selected the firing squad. He said he was terrified of the effects of a lethal injection, and he was very concerned because previously executed inmates had struggled for several minutes before being pronounced dead. Brad Sigmund was executed by firing squad at the Broad River Correctional Institution on March 7, 2025. At 6:05 p.m., the firing squad, made up of volunteer prison staff, shot Sigmund, who heaved in the chair and flexed his arms for a few seconds before going limp. He was declared dead at 6:08 p.m. Beneath the chair, there was a bowl to collect his blood. His attorney, religious advisors, the relatives of his victims, and 3 reporters were among those present for the execution. There was no warning or countdown before the squad opened fire on Sigmund, who was strapped to a chair with his legs shackled, wearing a hood over his head, and had a target over his chest, according to AP News journalist Jeffrey Collins, who was present and saw the execution. According to witnesses, Sigmund mouthed to his lawyer that he was okay even though his jaw was held in place with a sling. Collins reported seeing a jagged red spot about the size of a small fist in the vicinity of Sigmund's shooting spot after the bullets. Sigmund's chest moved 2 or 3 times, he added. There was no sound outside the rifle crack. Another reporter, Anna Dobbins, who was also present at the execution, described seeing a splash of blood as the bullet struck his body. Additionally, she said that Sigmund's body moved for a few seconds following that. She added that before being shot, he showed no outward indications of fear or trepidation. Weapons loaded with .308 Winchester ammo were used by the firing squad that performed the execution. This type of ammunition was made especially to fragment when it struck a target, destroying key organs like the heart and resulting in death almost immediately. Sigmund was the first person to be executed by firing squad in the United States since Ronnie Lee Gardner's June 2010 execution in Utah, and the fourth since 1976. Sigmund chose KFC for his final meal, which included fried chicken, green beans, gravy-topped mashed potatoes, biscuits, cheesecake, and sweet tea. He initially requested 3 buckets of fried chicken so that he can split them with the other inmates, but the officials denied his wish. His last words were, "I want my closing statement to be one of love and a calling to my fellow Christians to help us end the death penalty. An eye for an eye was used as justification to the jury for seeking the death penalty. At that time, I was too ignorant to know how wrong that was. Why? Because we no longer live under the Old Testament law, but now we live under the New Testament." Jesse Hoffman, March 18, Louisiana. On November 26, 1996, Jesse Hoffman Jr. kidnapped, essayed, and murdered a woman in Louisiana. He was only 18 years old. The 28-year-old advertising expert Mary Elliott had just left work that day and was on her way to the downtown New Orleans Sheraton parking garage where she usually left her car before work. Hoffman, a valet at that garage, met Elliott when he got there and directed the woman in her own car at gunpoint. He forced Elliott to drive to a nearby ATM and withdraw some cash. She gave him $200, and Hoffman asked Elliott to take them to a remote area of St. Tammany Parish. After forcing her to march to a patch of dirt, Hoffman essayed her while brandishing a gun. After making her kneel on a makeshift pier beside the Middle Pearl River, Hoffman shot her in the head to end her life. He then left her naked body there and disposed of her belongings and the murder weapon. Elliott's body wasn't found until 2 days later on Thanksgiving Day, November 28, 1996. A duck hunter discovered her remains and reported the finding to the authorities. Elliott's husband was able to identify his wife, who had gone missing after failing to show up for dinner. Authorities were also notified by a couple who found Elliott's belongings and clothes in an abandoned lot. Among the documents were 3 ATM receipts connected to the same ATM from which Elliott had taken out money for Hoffman. The police were able to arrest Hoffman based on the description of a man who was seen with Elliott in the ATM photographs. Eventually, Hoffman admitted his involvement in the killing. Hoffman's execution was the first in which Louisiana used nitrogen hypoxia as method of execution. Only 4 other executions in the U.S. have involved the use of nitrogen gas, and those were all carried out in Alabama, the only other state with a protocol for the technique. Hoffman was declared dead at the Louisiana State Penitentiary at 6:50 p.m. after refusing to make a final statement before the gas started to flow. While one witness described the inmate convulsing during the procedure, authorities said that the nitrogen gas flowed for 19 minutes during what one official described as a flawless execution. Hoffman also declined to have a special last meal. Aaron Gunches, March 19, Arizona. On November 14, 2002, Gunches went to his girlfriend's place. Upon his arrival, he discovered that she had a confrontation with her ex-husband, Ted Price, who had come to see her earlier that day. Price had been struck in the face by a telephone and was lying on the floor, confused. Gunches then had his girlfriend and her friends help him get into his car, ostensibly with the intention of dropping Price off at a bus stop. However, Gunches soon found out that he did not have enough money to buy Price a bus ticket. Then Gunches and a friend drove Price into the desert. As Price exited the vehicle, Gunches shot him 4 times, killing him. Gunches entered a guilty plea to Ted Price's murder in 2004, and he received a death sentence in 2008. Along the years, he had asked for his execution to be carried out several times. On March 19, he was lethally injected with pentobarbital and was pronounced dead at 10:33 a.m. According to witnesses, Gunches had no last words before the execution while sitting upright on a gurney, wrapped in what appeared to be a white onesie and tucked in with a sheet. Following the fatal injection, the inmate snorted and took several deep breaths. Gunches' final meal consisted of 2 sandwiches, French fries, onion rings, a double Western bacon cheeseburger, and baklava for dessert. Wendell Grissom, March 20th, Oklahoma. Grissom and Jesse Jones broke into the house of a mother of 2 who also had a visitor, her close friend Amber Matthews. Grissom shot Drew Koff several times, but she managed to run away and survived. Her friend Amber was killed while she was hiding in a bedroom with Drew's 2 toddlers. Fortunately, the children were not harmed. At the Oklahoma State Penitentiary in McAllister, Grissom, 56 years old, was declared dead at approximately 10:13 a.m. following a fatal injection of a 3-chemical cocktail. His final moments were witnessed by his own family and numerous of his victims' relatives, according to state corrections officials. Grissom's final meal was a pint of vanilla ice cream, a pint of Coca-Cola, and a Canadian Bacon Supreme pizza. His final statement was a long one, in which he apologized for his actions and expressed his regret. In part, his last words said, "I pray that you all can forgive me, not for my sake, for your sake. It is the only way you will find God in this." Edward Thomas James, March 20th, Florida. He was sentenced to death for the September 1993 murders of an 8-year-old girl and her grandmother in Castleberry, Florida. James was renting a room from Elizabeth Ann Dick, the mother of a friend of his. James came home from a party on September 20th, 1993, to discover that Dick's 4 grandchildren were sleeping in the living room. He took Toni Marie Neuner, 8 years old, by the neck and choked her until she passed out. Then he carried her to his bedroom and essayed her before placing her between his bed and the wall. Later, she died from the strangulation. James then went to Dick's bedroom, where he repeatedly stabbed her with a knife and struck her in the head with a candlestick. Wendy, Tony's sister, who was 9 years old, came to the bedroom as she heard her grandmother screaming. Wendy was restrained by James and placed in the restroom. After retrieving a butcher knife from the kitchen, he went back to Dick's bedroom and stabbed her in the back. James took her car after having a shower and stealing jewels from Dick's bedroom. James, 63 years old, received a 3-drug injection in Florida State Prison and was declared dead at 8:15 p.m. He said he did not want to make a final statement while he waited for the injection. His arms flinched when the medications were given, and he began to breathe heavily before becoming still. I couldn't find what his last meal was, but the rule in Florida is that inmates can order anything that is under $40, and if the desired meal is made locally. Christopher Sepulvado, March 17, Louisiana. Sepulvado was on death row for 33 years for brutally beating and scalding to death a 6-year-old boy back in 1993. He was supposed to be the first inmate to be executed with nitrogen gas in Louisiana on March 17, but he passed away from natural causes in the prison infirmary on February 22. He was 81 years old. This April, 4 death row inmates took their final breaths, each one leaving behind a trail of devastation that can never be undone. Michael Tanzi, April 8, Florida. After more than 2 decades on Florida's death row, Michael Tanzi was executed for the brutal 2000 murder of 49-year-old Janet Acosta. In the days leading up to his death, his legal team launched a final, unusual appeal, arguing that his morbid obesity could make lethal injection unbearably painful. But the courts ultimately rejected the claim, and on April 8, the state carried out the execution as scheduled. On April 25, 2000, Janet Acosta was sitting in her van during her lunch break at the Japanese Gardens in Miami, reading a book. Tanzi, stranded in the city and trying to get back to Key West, approached her and asked for a cigarette and the time. Then, without warning, he punched her in the face and forced his way into the van. Holding her at knife point with a razor, Tanzi drove off, keeping her subdued by gripping her wrist. At a gas station in Homestead, he gagged her with a towel and bound her with rope from the van. He threatened to kill her if she made a sound. Acosta handed over $53 in cash, and Tanzi tried to use her ATM card to buy cigarettes and a Coke. He then coerced her into performing oral sex. After realizing he had broken her teeth during the initial assault, he stopped. Later, in Tavernier, Tanzi again used threats to get Acosta's PIN number and withdrew money from her account. He also stopped to buy more razor blades and duct tape. By around 6:30 p.m., they had reached Sugarloaf Key. Fearing Acosta could identify him, Tanzi decided to kill her. On a remote road in Cudjoe Key, he strangled her with rope, pausing to muffle her face with duct tape before continuing until she was dead. He left her body in a wooded area where he believed it wouldn't be found. After the murder, Tanzi used her ATM card to shop, eat, and visit friends in Key West. He planned to change the van's appearance, buy drugs, and go into hiding. But on April 27, police, who had been surveilling the van after Acosta was reported missing, caught him returning to it. He had receipts from her bank account in his pocket. Tanzi immediately confessed to the crime. In custody, he provided detailed statements and showed investigators where he had discarded the body, rope, and duct tape. He initially pleaded not guilty, but changed his plea before trial, admitting to first-degree murder, carjacking, kidnapping, and armed robbery. During the penalty phase, defense attorneys presented evidence of severe childhood trauma and mental illness. Experts testified that Tanzi had been essayed starting at age 8 and was diagnosed with PTSD, bipolar disorder, ADHD, and antisocial personality disorder, among others. His mother recalled signs of emotional damage following his father's illness and death, as well as the prolonged abuse by an older boy. Despite this, the jury unanimously recommended a death sentence. Tanzi was also linked to the 1999 murder of Carolyn Holder in Massachusetts. Although he was never tried in that case, investigators believed he stabbed and strangled the 36-year-old woman. Prosecutors declined to pursue the case since he was already sentenced to death in Florida. As his execution date approached, Tanzi's lawyers filed a last-minute appeal, arguing that his extreme obesity could interfere with the sedative used in Florida's lethal injection protocol. They claimed the drug, etomidate, might not keep him unconscious, putting him at risk of experiencing the feeling of being burned from the inside while paralyzed and unable to react. The state pushed back, saying the drug had been successfully used in numerous executions, and there was no evidence it would fail in Tanzi's case. Circuit Judge Timothy Cohen dismissed the appeal, and the Florida Supreme Court declined to intervene. Despite the dramatic claims, the execution proceeded as scheduled. Tansey had a spiritual advisor as his only visitor after he got up at 4:45 a.m. on the day of his execution. His final meal consisted of a candy bar, ice cream, corn, bacon, and pork chop. At Florida State Prison, Tansey received a 3-drug injection and was declared dead at 6:12 p.m. He made the final statement saying, "I want to apologize to the family," prior to reciting a Bible passage just before the drugs started to flow. His chest heaved for 3 minutes, then stopped, and the corrections officers shook his shoulders and called his name twice to see if he was still conscious, but he was not. Mikal Mahdi, April 11, South Carolina. Mikal Mahdi remained on death row for the 2004 killing of a South Carolina police officer during a violent, multi-state crime spree. Originally from Virginia, Mahdi embarked on a 3-day rampage in July 2004 that left 2 men dead and included carjackings, robberies, and multiple assaults. On July 15, 2004, Mahdi murdered 29-year-old convenience store clerk Christopher Jason Boggs in Winston-Salem, North Carolina. 2 days later, he carjacked a man in Columbia, South Carolina, and fled to a nearby farm in Calhoun County. There, he encountered 56-year-old James Myers, an off-duty police captain, and killed him before setting his body on fire. Mahdi evaded capture for 4 days after Myers' death, but he was arrested in Florida on July 21, 2004. He was extradited to South Carolina, where he was later found guilty and sentenced to death in 2006. In 2011, he was transferred to North Carolina, tried for the murder of Boggs, and received a life sentence without parole. Despite multiple appeals, Mahdi's death sentence was upheld. The South Carolina Supreme Court signed his death warrant on March 14, 2025, scheduling his execution for April 11, 2025. Mahdi chose to die by firing squad. He was the second person in the state to do so this year, stating it was the least cruel of the available methods. On July 14, 2004, 21-year-old Mahdi stole Virginia license plates, a station wagon, and a .38 caliber handgun from a neighbor before heading south. The next day, he entered a convenience store in Winston-Salem, picked up a beer, and fatally shot Christopher Boggs in the face when the clerk asked for ID. Mahdi fired another round into Boggs's body before fleeing with a beer. After the murder, Mahdi drove to Columbia, South Carolina. There, he carjacked Corey Pitts and armed himself with a revolver. He then swapped the license plates with the ones he had stolen in Virginia. After 35 minutes of driving, Mahdi stopped at a gas station and attempted to use a credit card to pay for fuel. When the pump refused the card and employees became suspicious, Mahdi fled on foot. Later that day, he arrived at a farm in Calhoun County owned by Captain James Myers of the Orangeburg Department of Public Safety. While Myers celebrated family birthdays at the beach, Mahdi rummaged through the property's workshop looking through firearms and watching TV. When Myers returned to the farm, Mahdi ambushed him with a .22 caliber rifle, held him hostage, and ultimately shot him 9 times. He then poured diesel on Myers' body and set it ablaze. Mahdi fled in Myers' police-issued truck, taking multiple firearms with him. Myers' wife, Amy Tripp Myers, also a law enforcement officer, became alarmed when he failed to return home. She discovered his burned body and alerted authorities. Florida police apprehended Mahdi on July 21, 2004, after spotting him driving Myers' truck. He attempted to flee on foot with one of Myers' weapons, but ultimately dropped it and surrendered. In 2009, while incarcerated at Lieber Correctional Institution, Mahdi and serial killer Quincy Allen plotted to kill a corrections officer. They crafted homemade knives and attacked guard Nathan Sasser after luring him to the prison yard. Though seriously injured, Sasser survived the stabbing, but later developed PTSD and left law enforcement. While Mahdi and Allen were charged for the assault, prosecutors dropped the case because both men were already sentenced to death. Quincy Allen's sentence was eventually overturned, and in July 2024, he was resentenced to life after accepting a plea deal. Mahdi, however, remained on death row. In 2023, Mahdi joined a group of inmates who sued South Carolina over the use of the electric chair and firing squad, claiming both methods amounted to cruel and unusual punishment. The courts dismissed the case. On March 28, 2025, Mahdi officially chose the firing squad as his method of execution, saying he feared being burned and mutilated in the electric chair or suffering a prolonged death by lethal injection. His lawyer called it the least evil of the three choices. Mahdi filed a last-minute appeal, arguing that his original defense team failed to present mitigating evidence about his traumatic upbringing. The court rejected the appeal, agreeing with prosecutors who maintained that Mahdi's background did not excuse his crimes. Born on March 20, 1983 in Virginia, Mahdi's childhood was marked by instability and neglect. His father, Sharif, had converted to Islam, married a 16-year-old, and struggled with the law and employment. Mahdi's mother left in 1986, and by 1991, Mahdi and his brother were sent to live with relatives. At 8 years old, Mahdi moved in with an uncle in Maryland and attended school in Baltimore. He struggled academically and behaviorally, especially with reading comprehension and respect for authority. School reports noted low self-esteem and poor interpersonal skills. In 1992, Mahdi was involuntarily hospitalized for a suicide threat. He later moved back in with his father and brother in 1997 and committed his first burglary that same year. Convicted of multiple charges, Mahdi spent time in juvenile detention before moving to Richmond with his mother. In 2001, Mahdi was sentenced to 93 months in prison for assaulting a Virginia police officer. Released in May 2004 and placed on 15 years probation, he launched his deadly spree just 2 months later. At 6:05 p.m. on the day of his execution, Mikal Mahdi, 42 years old, was declared dead after the firing squad placed a hood over his head and fired 3 bullets into his heart at once. Witnessing the execution, his lawyer described it as barbaric and described it as a horrifying act that belongs in the darkest chapters of history, not in a civilized society. Mahdi refused to give a final statement. According to a reporter who was present at the execution, Mahdi screamed as the bullet struck him and then let out 2 groans around 45 seconds later. Mahdi died less than 4 minutes after the rounds were fired. His last meal was a ribeye steak, mushroom risotto, broccoli, collard greens, cheesecake, and sweet tea. Moises Sandoval Mendoza, April 23, Texas. He had been found guilty of the 2004 murder of 20-year-old Rochelle Tolson in Collin County, Texas. Mendoza strangled her, kept her body hidden behind his house for several days, and later burned and buried it in a remote rural area beneath a brush pile. Both Mendoza and Rochelle had attended Farmsville High School and graduated in 2001, though they didn't know each other well at the time. They reconnected around 6 weeks before the murder, while attending Collin County Community College. On the night of March 17, 2004, Mendoza was reportedly drinking heavily at a friend's house with 2 other men. By the next day, Rochelle had gone missing. Her 6-month-old baby was found alone at home, which led her family to immediately report her disappearance to the police. The scene inside her home was chaotic, with overturned furniture suggesting a possible struggle or abduction. Authorities later learned that Mendoza had picked Rochelle up from her home after the baby had gone to sleep. He confessed to a friend, Stacy Marie Garcia, that he had strangled Rochelle. In her statement to law enforcement, Garcia said Mendoza admitted to essaying her, stabbing her in the neck, and initially hiding her body behind his home on Jackson Street. He later relocated the body, wrapped in a tarp, to Brushy Creek after being questioned by police. The remains were discovered when a man hunting for arrowheads spotted 2 feet sticking out from a brush pile. The body had been badly burned and dental records were required for identification. Mendoza reportedly told Garcia that he had torched the body to destroy any fingerprints or evidence. He also claimed that he and Rochelle were in a relationship, though friends of the victim refuted this. According to them, Rochelle had only recently met Mendoza at a party and she was not interested in him romantically. Some speculated that her rejection may have triggered the violence. The brutal murder shocked the small community of Farmsville. Neighbors and acquaintances described Mendoza as polite, hard-working young man who often helped his father. Many were stunned that he could be responsible for such a horrific crime. However, Mendoza did have a documented history of violent behavior. In April 2003, police records showed he had been charged with misdemeanor assault after allegedly attacking his sister in their front yard. The case was dismissed after his sister chose not to pursue charges. Additionally, Mendoza was awaiting trial for 3 counts of aggravated robbery with a deadly weapon in connection to gunpoint robberies at Richland College in Dallas in March 2003. In January 2005, Mendoza was also charged with several counts of child essay, but those charges were dropped after his conviction for capital murder. Following his conviction, Mendoza filed numerous appeals, claiming ineffective legal representation during his trial and post-conviction proceedings. However, both federal courts and the Texas Court of Criminal Appeals denied his appeals. After years of legal battles, the court determined he had exhausted all options and set his execution date. Mendoza was executed by lethal injection on April 23, closing a chapter on a case that left deep scars in the local community and among those who knew and loved Rochelle Tolson. His last words were directed towards his family and the victim's family. "I am sorry for having robbed you of Rochelle's life. I am sorry for that. I know nothing that I could ever say or do would ever make up for that. I want you to know that I am sincere. I apologize." The family members of the victim were her parents, one brother, a cousin, and an uncle. Her daughter was not present at the execution. Mendoza's family was seen very distraught in the witness room. His last words towards them were, "I love you, I am with you, I am well and at peace. You know that I am well and everything is love." His wife, his sister, and 2 friends were there in his final moments. Texas doesn't offer any special final meals since 2011, so he ate what was on the menu that day. James Osgood, April 24, Alabama. Osgood was executed by lethal injection at the William C. Holman Correctional Facility in Atmore, Alabama. His execution followed a series of legal proceedings and appeals stemming from his conviction for the brutal 2010 essay and murder of 44-year-old Tracy Lynn Brown in Chilton County. The Alabama Supreme Court had authorized the execution after a request was filed by the Alabama Attorney General's office on February 11, 2025. The court granted the request on March 6. Governor Kay Ivey subsequently set the official execution date. Osgood and his then-girlfriend, Tonya Van Dyke, attacked Brown at her home. Court documents revealed that Brown, who was Van Dyke's cousin, was coerced at gunpoint to engage in sex acts. She was then savagely beaten, stabbed in the back, and had her throat slit. Her body was discovered on October 13, 2010, after she failed to show up for work. Both Osgood and Van Dyke were arrested and charged in connection to the crime. Van Dyke received a life sentence without the possibility of parole, while Osgood was convicted on 2 counts of capital murder committed during the course of both first-degree essay and first-degree sodomy. Although Osgood's conviction was upheld by the Alabama Court of Criminal Appeals, his sentencing was initially overturned due to errors in the judge's instructions to the jury during the penalty phase. The case was sent back to Chilton County Circuit Court for a new sentencing hearing. However, in a rare move, Osgood requested to be sent back to death row before the resentencing could take place. When the judge asked why he would make such a request, Osgood reportedly said he believed an eye for an eye and felt he deserved to die for what he had done. Tracy Brown's murder shocked the community and devastated her family. The nature of the crime was particularly brutal and personal, given the family connection between the victim and one of the perpetrators. Osgood's execution was the last to be carried out in the U.S. in April 2025, closing a dark chapter in a case that had haunted Chilton County for nearly 15 years. At 6:09 p.m., the witness room's curtains opened. Osgood turned to face relatives seated in a witness room as the execution began. As he passed out, friends and family wept softly. Wearing a khaki prison uniform and strapped on a gurney, Osgood spoke about his victim in his final moments. His last words were, "I haven't said her name since that day. I was not sure if I should say it. Tracy, I apologize." Around 6:15 p.m., his head fell back onto the gurney as his breathing grew laborious and heavy. By approximately 6:18 p.m., his breathing was no longer detectable. He was declared dead a few minutes later. 5 attempts were made to attach the 2 necessary IV lines to Osgood. His final meal was pizza. He declined his lunch tray but ate breakfast and some snacks. On Thursday, Osgood had meetings with 11 individuals, including his sister and daughter, other relatives, friends, and a lawyer. He also had a phone conversation with someone. This May, 5 men were put to death across the US, and each case was darker, more twisted, and more tragic than the last. Let me take you inside their last moments. Jeffrey Hutchinson, Florida, May 1st, 2025. Jeffrey Glenn Hutchinson was sentenced to death for the 1998 murders of his girlfriend and her 3 children in Crestview, Florida. A former Army Ranger and Gulf veteran, Hutchinson struggled with his mental health after returning from combat. His first marriage ended in divorce, and the second relationship with Renee Flaherty eventually turned fatal. On September 11, 1998, after an argument with Renee, Hutchinson left their home, went to a bar, and told the bartender he was angry. Less than an hour later, he returned with a shotgun and fatally shot Renee, 32, and her 3 children, Geoffrey, 9, Amanda, 7, and Logan, 4, in their home. All victims were shot in the head. Geoffrey was also shot in the chest. Hutchinson called the police right away and he was arrested at the scene. He was charged with 4 counts of first-degree murder. At trial, he claimed that masked intruders committed the killings, then later said it was a crime of passion committed under the influence of alcohol. The jury didn't buy any defense. On January 18, 2001, Hutchinson was found guilty on all charges. The judge sentenced him to life in prison for Renee's murder and death for the killings of the children, citing their young age and the brutal nature of the crime, especially Geoffrey's, whom Hutchinson shot twice. Despite appeals citing mental illness and military trauma, his convictions and sentences were upheld. The Florida Supreme Court ruled the domestic nature and lack of prior violence didn't outweigh the severity of the crimes. Governor Ron DeSantis signed the death warrant of Jeff Hutchinson on April 1, 2025. The Flaherty family murders were among the most devastating in Okaloosa County's history. In the aftermath, grief counselors were sent to the children's school to support the community. Hutchinson was executed shortly after 8 p.m. on Thursday at Florida State Prison in Rayford, using the state's standard 3-drug trial injection protocol: etomidate, rocuronium bromide, and potassium acetate. He was pronounced dead at 8:14 p.m., according to the Florida Department of Corrections. This was Florida's 4th execution of the year and the 15th in the U.S. in 2025. Hutchinson declined to give a final statement and reportedly mumbled to himself as the execution began, according to the Associated Press. His last meal consisted of salmon, mahi-mahi, asparagus, baked potato, and iced tea. Hutchinson's family fought till the very end to save his life and postpone the execution. There was some evidence that he may not have committed the murders, and he actually maintained his innocence all these years. One of the most compelling pieces of evidence in this case was the fact that he had blood spatter under his shoes, something that couldn't have happened if he was the shooter. Another thing that his loved ones tried to explain was that Hutchinson was not actually the one that called 911, but it was in fact the real murderer who was trying to frame Hutchinson. They said that the reason he was put into this situation was that some people were trying to involve him in robberies because he had military expertise and he refused to help them. I will admit that this was one case in which I did have doubts about his innocence. I know that there are many things pointing out that he was the killer, but at the same time, there may be some details that were not properly investigated. I'm not saying he was innocent, but I do wish that things were crystal clear. A lot of you guys will say that the justice system in the US is based on proving guilt beyond reasonable doubt, and I know that's how it works. I support the death penalty, but my personal belief is that nobody should be executed without knowing 110% that there is no possibility whatsoever of punishing the wrong person. Glenn Rogers, Florida, May 15, 2025. Nicknamed the cross-country killer and the Casanova killer, Glenn Rogers was convicted of first-degree murder in two separate trials for the killings of two women, one in Florida in 1997 and another in California in 1999. He was also suspected in several other homicides across the U.S. His killing spree began on September 28, 1995, and after his first confirmed murder, he was added to the FBI's 10 most wanted fugitives list. Rogers received death sentences both in Florida and in California. After spending nearly 30 years on death row, he was finally executed on May 15, 2025. Rogers was born in Hamilton, Ohio, one of 7 children of Edna and Claude Rogers, a hydropulp operator at the local Champion paper mill. His brother Clay is among his surviving siblings. Glenn was expelled from junior high school before turning 16. Following his expulsion, Rogers impregnated his 14-year-old girlfriend, Deborah Ann Nix, and they got married. The couple had a second child in 1981. Nix, however, filed for divorce in 1983, citing physical abuse. Authorities in Hamilton, Ohio, suspected Rogers of the 1993 murder of an elderly man, after which he left the state and reappeared in California. In 1995, he was linked to the killings of 4 women across California, Mississippi, Florida, and Louisiana. Rogers was arrested in Kentucky on November 13, 1995. Initially, he claimed responsibility for nearly 70 murders, but later retracted the statement, saying he was just joking and had not killed anyone. Let's talk about the victims. Mark Peters, Hamilton, Ohio. On January 10, 1994, the remains of 71-year-old Mark Peters, a retired electrician and veteran, were found in a family-owned cabin in Kentucky. Peters had taken Rogers in before he went missing in October 1993. Rogers vanished around the same time. Peters' body was found tied to a chair and concealed under furniture. Police were led to the scene by Rogers' brother Clay. Sandra Gallagher, Los Angeles, California. On September 28, 1995, Rogers was seen with 33-year-old Sandra Gallagher at a bar in Van Nuys. The next day, her strangled and burned body was found in her truck near Rogers' apartment. He fled afterwards and was suspected of additional murders in other states. He was convicted of her murder in June 1999 and sentenced to death in California. Linda Price, Jackson, Mississippi. Linda Price met Rogers at the Mississippi State Fair in fall 1995. They briefly lived together. The 34-year-old single mother vanished just before Halloween, and her body was later found in her bathtub. She shared traits with Rogers' other suspected victims, including red hair and being in her 30s. Guys, it started raining and there's a lot of thunder going on, so if you're hearing those noises, I'm sorry. Tina Marie Cribbs, Tampa, Florida. On November 5, 1995, Cribbs was last seen leaving a bar with Rogers. Her body was found 2 days later in a motel bathtub, having been stabbed multiple times. Fingerprints and evidence linked Rogers to the crime. He was arrested on November 13 while driving her car. Rogers claimed she had lent him the vehicle. In July 1997, he was convicted of her murder in Florida and sentenced to death. Andy Giles Sutton, Bossier City, Louisiana. A known acquaintance of Rogers, Sutton was found dead in her apartment on a punctured waterbed. Rogers fled the state, leading police on a 13-mile chase in Kentucky before being captured. His arrest was caught on film by a local TV crew. After being sentenced to death for Cribbs' murder, Rogers' scheduled 1999 execution was delayed due to multiple appeals, all of which were ultimately denied. He challenged the conviction on several grounds, including prosecutorial misconduct and improper testimony. His final appeal was denied in 2011. On April 15, 2025, Florida Governor Ron DeSantis signed Rogers' death warrant, setting the execution for May 15. Rogers was the 5th Florida inmate scheduled for execution this year. He attempted to stop the execution by citing childhood essay and concerns about the drugs used in the lethal injection, but the Florida Supreme Court denied the appeal on May 9. The U.S. Supreme Court also rejected the final appeal on May 14. Rogers, 62 years old, was executed according to plan at Florida State Prison, and he was pronounced dead at 6:16 p.m. His final meal was pizza, chocolate cake, and soda. He was the 16th person executed in the US in 2025. In his final statement, Rogers addressed the victims' families and then President Donald Trump. I know there's a lot of questions that you need answers to. I promise you, in the near future, the questions will be answered, and I hope in some way will bring you closure. President Trump, keep making America great. I'm ready to go. Matthew Johnson, Texas, May 20, 2025. On the morning of May 20, 2012, 76-year-old Nancy Judith Harris arrived early for her shift at the Final Whip convenience store in Garland, Texas. Harris, a beloved grandmother known for her kindness and routine, had no idea her workday would end in a brutal and senseless act of violence. Shortly after she began her shift, a man named Matthew Lee Johnson entered the store carrying a container of lighter fluid and a lighter, items he would soon use to commit an unthinkable crime. Surveillance footage from inside the store later revealed Johnson approaching Harris at the counter. Without warning, he began pouring lighter fluid all over her, demanding access to the cash register. Harris, trying to comply in hopes of avoiding escalation, she opened the register as instructed. Johnson then grabbed the contents, bills, coins, and even Harris's personal belongings, including her ring, 2 cigarette lighters, and cigarette packs. As Harris stood with her back to him, Johnson ignited the lighter fluid, setting her ablaze. As flames consumed her body, Harris ran to a nearby sink and desperately tried to extinguish the fire. She attempted to remove her burning shirt, leaned over the sink again, but was still engulfed in flames. Meanwhile, Johnson casually walked out of the store, taking candy from the counter as he exited. Outside, Harris managed to flee the building, screaming for help. A passerby who witnessed the horrifying scene rushed to her side with a fire extinguisher and attempted to put out the flames. Emergency responders arrived shortly after, finding Harris severely burned but conscious and able to provide a description of her attacker, a heavy-set black man with short hair and a round face. Law enforcement quickly canvassed the area and located witnesses who had seen a man matching Harris's description attempting to enter nearby homes. Approximately an hour later, officers apprehended Johnson after a short foot chase. He was found in possession of the stolen cash and items taken from the store. Initially charged with robbery and assault, his charges were upgraded to capital murder after Harris succumbed to her injuries 5 days later on May 25, 2012 at Parkland Memorial Hospital's burn unit. Nancy Harris was a deeply loved member of her community. Her family described her as a warm and caring person, someone who spent her Fridays with her granddaughters in what they called Nini days, which included trips to the dollar store, lunch at McDonald's, and games at home. She had previously overcome health scares and was regarded as a resilient and joyful woman who found immense pleasure in small, simple routines with her family. Matthew Lee Johnson, born on September 17, 1975 in Dallas County, had a long history of criminal behavior and personal instability. Raised in a difficult and reportedly abusive environment, he began engaging in criminal activity by age 15. His rap sheet included car theft, resisting arrest, and attacking police officers. Over the years, his offenses escalated, including a 2011 theft from an employer. Despite his criminal history, Johnson had periods of stability. He was married and had 3 daughters by the time of his arrest. However, his life remained marked by addiction and instability. Johnson stood trial for capital murder in Dallas County beginning on October 28, 2013. Prosecutors argued that Johnson deliberately and cruelly murdered Harris during the course of a robbery. They presented extensive evidence, including the store's surveillance footage, eyewitness testimonies, and physical evidence, such as the stolen items found in Johnson's possession. Prosecutors emphasized Johnson's calm demeanor after setting Harris on fire as a sign of his cold and calculated nature. During the punishment phase of the trial, his attorneys tried to argue for mercy. He took the stand and claimed that he was high on drugs at the time of the attack and that he never intended to actually harm Harris. He just wanted to scare her. He expressed remorse and said he would like to live to see his daughters grow up. The defense presented psychological and expert testimony highlighting Johnson's long history of drug addiction, which reportedly began during his adolescence. They also introduced evidence of childhood trauma, including essay and testimonies from family members who detailed his struggles and attempts to overcome his addiction. The prosecution countered with evidence of Johnson's long criminal record and the brutality of the crime. They argued that Johnson posed a continuous threat to the society and that he deserved the harshest punishment possible. During victim impact statements, Harry's family addressed the court with raw emotion. Her children and grandchildren described the agony of losing her in such a violent way. One of her sons vowed to witness Johnson's execution, while another stated that he would never forgive Johnson, hoping the memory of Harris's screams would haunt him forever. Her granddaughters also expressed disbelief that Johnson felt any true remorse and emphasized the deep void left by Harris's absence. On October 30, 2013, the jury unanimously found Johnson guilty of capital murder. Less than 2 weeks later, on November 8, he was sentenced to death. Johnson reportedly showed no emotion as the verdict was read, and his attorney said that it was because Johnson expected this outcome. Over the next decade, Johnson pursued multiple appeals at the state and federal levels. Each was ultimately rejected. In November 2015, the Texas Court of Criminal Appeals upheld his conviction and sentence, rejecting 65 separate claims of error. In June 2016, the U.S. Supreme Court declined to hear his case. Further efforts for relief were denied in 2019 by the Texas Court of Criminal Appeals. In 2022, they were also denied by the U.S. District Court for the Northern District of Texas, and in 2023 by the Fifth Circuit Court of Appeals. His final appeal to the U.S. Supreme Court was denied on February 20, 2024. By early 2025, Johnson had exhausted all possible legal remedies. In January, a Dallas County judge signed his death warrant, scheduling his execution for May 20, 2025, exactly 13 years to the day after he set Nancy Harris on fire. On May 16, just days before his execution, the Texas Board of Pardons and Paroles denied Johnson's request for clemency. His attorney confirmed that no further appeals would be made. On the day of his execution at the Huntsville unit, Johnson was given the opportunity to speak. In his final statement, he turned to Harris's family and said, "As I look at each one of you, I can see her on that day. I please ask you for forgiveness. I never meant to hurt her." He was executed by lethal injection and pronounced dead at 6:53 p.m. Central Standard Time. Because he was executed in Texas, he did not get a final special meal. Benjamin Ritchie, Indiana, May 20, 2025. On September 29, 2000, Benjamin Donnie Ritchie fatally shot 31-year-old officer William Toney, a police officer in Beech Grove, Indiana. Ritchie was arrested shortly after and faced multiple charges, including the murder of a law enforcement officer. He was found guilty on August 10, 2002, and sentenced to death by a Marion County judge on October 15, 2002. Ritchie's legal team pursued numerous appeals, all of which failed. In his final efforts, he argued that his death sentence should be overturned due to severe mental health disorders and cognitive impairments. These, he claimed, were the result of childhood abuse, personal drug use, and his mother's substance abuse while pregnant with him. However, the Indiana Supreme Court ultimately denied his request to file a successive post-conviction relief petition. The court instead approved the state's request to set an execution date, which was carried out on May 20, 2025 at Indiana State Prison, where Ritchie had been incarcerated. Ritchie's life was fraught with adversity from the beginning. Born on May 3, 1980, he never knew his biological father. His mother, Marian Martin, worked as a stripper and struggled with addiction to drugs and alcohol, which continued during her pregnancy. By the time Ritchie turned 3, she had abandoned him twice. Her husband, Donald Peoples, took custody of Ritchie's older half-brothers, but left Benjamin behind upon learning he was not the boy's father. Initially named Benjamin Peoples, he was later adopted by Verna and Oscar Ritchie and took their surname. Ritchie's childhood and adolescence were marked by academic and behavioral difficulties. He repeated the first grade and left school in 9th grade. He began receiving counseling from a church minister as early as 3rd grade and was admitted for treatment at Community North Hospital by age 10. Diagnosed with bipolar disorder and other cognitive issues, Ritchie's struggles were attributed to his unstable upbringing and the lasting effects of prenatal exposure to drugs and alcohol. In August 1998, he was convicted of burglary. By the time of the shooting in 2000, he was no longer in prison but under supervised probation. That September, he and two associates stole a white van from a Beech Grove gas station. About 2 hours later, Officer Matt Hickey identified the vehicle and began pursuit. He was joined by officers Robert Mercury and William Toney. During the chase, only Ritchie and 20-year-old Michael Greer remained in the stolen van. When the vehicle stopped in a residential yard, both fled on foot. Officer Hickey apprehended Greer while Officer Toney chased Ritchie. Ritchie drew a firearm and shot Officer Toney 4 times. One of the bullets pierced above the officer's bulletproof vest, fatally wounding him. Officer Toney had served on the police force for just 2 years. Ritchie was arrested the next day at the home of Michael Moody, the third participant in the theft. Prosecutor Scott Newman soon confirmed that the state would seek the death penalty. Due to media interviews where Ritchie claimed the shooting was accidental, a story supported by a friend, a gag order was imposed to prevent further public discussion before the trial. Initially, Michael Greer also faced murder charges. However, as part of a plea agreement, he pled guilty to lesser charges, including aiding a criminal, theft and trespassing, and agreed to testify against Ritchie. Greer faced a maximum sentence of 8 years. Moody was convicted of car theft and possessing an unlicensed firearm with a maximum 4-year sentence. Ahead of trial, Ritchie's attorneys filed a motion citing the 2002 U.S. Supreme Court decision in Ring v. Arizona, which held that only juries, not judges, can impose a death sentence. They argued Indiana's laws allowing judicial override were unconstitutional. Judge Patricia Gifford agreed in part, declaring judicial overrides unconstitutional, though she upheld the broader legality of the death penalty, allowing it to remain on the table. Ritchie's trial began on August 5, 2002, after jury selection at the end of July. The pretrial gag order expired when the proceedings started. On the trial's second day, Greer testified against Ritchie. The jury found Ritchie guilty of murder, car theft, carrying an unlicensed firearm, and resisting arrest. During the sentencing phase, Ritchie's defense highlighted his traumatic childhood and mental disabilities, arguing he deserved leniency. The prosecution rejected these arguments, asserting that many endure hardship without committing murder. After over 3 hours of deliberation, the jury unanimously recommended the death penalty. Ritchie reportedly laughed upon hearing the verdict. On October 15, 2002, Judge Gifford formally sentenced 22-year-old Ritchie to death. Prior to the sentencing, Officer Toney's widow gave a victim impact statement accusing Ritchie of cowardice and expressing hope that he would suffer in prison until his execution. Ritchie spent over 2 decades on Indiana death row. In 2014, he was among just 11 inmates awaiting execution. By 2020, the number had dropped to 8. And it's raining. Again. In 2024, it came to light that Ritchie had been in a 4-year relationship with a Swedish woman who first learned about him through a documentary. She even traveled to visit him in prison. They briefly discussed an escape plan which Ritchie called off to protect her. After their relationship ended, she struggled with substance abuse but eventually recovered and became a mother. Ritchie's legal battles persisted for years. The Indiana Supreme Court denied his first appeal in 2004 and his second in 2007. He alleged ineffective legal representation, which the court rejected. In 2017, the U.S. Supreme Court dismissed his final appeal. In September 2024, Indiana's Attorney General requested the court schedule Ritchie's execution. At the time, he was one of 4 death row inmates who had exhausted all appeals. He was also the only one convicted of killing a police officer, while 2 others awaited trial for similar crimes. Ritchie's attorneys submitted a final motion in response to the death warrant, claiming previous legal counsel had failed to explore potential fetal alcohol spectrum disorder or childhood lead exposure. While the court considered the arguments, Indiana resumed execution by putting Joseph Corcoran to death in December 2024, ending a 15-year hiatus caused by drug shortages. On April 15, 2025, the Indiana Supreme Court rejected Ritchie's final motion and scheduled his execution for before dawn on May 20, 2025. In the majority opinion, Justice Geoffrey Slaughter stated that the new evidence about cognitive issues wouldn't have changed the jury's decision. Chief Justice Loretta Rush dissented, arguing that the evidence warranted further review. Two clemency hearings were scheduled on May 5 and May 12, 2025. During the first, Ritchie apologized for the murder, claiming he had changed and wanted to contribute positively if spared. At the second hearing, Officer Tony's family and friends urged the board to proceed with the execution. On May 14, both the parole board and Governor Mike Brown denied clemency. Ritchie also petitioned the U.S. Supreme Court and the Seventh Circuit Court of Appeals for a delay. Both appeals were denied by May 19, the night before his execution. On May 20, 2025, at the age of 45, Benjamin Donnie Ritchie was executed by lethal injection at Indiana State Prison. The Indiana Department of Corrections reported that Benjamin Donnie Ritchie's execution began shortly after midnight. He was declared dead at 12:46 a.m. following the administration of a single dose of pentobarbital. For his final meal, he chose Olive Garden's tour of Italy, which features fettuccine alfredo, lasagna, and chicken parmigiana. His final words were, "I love my family, my friends, and all the support I've gotten. I hope they all find peace." Information about the execution of the 45-year-old was limited, as media were not allowed to observe the procedure. Steve Schutt, Ritchie's defense attorney and one of the few witnesses, told the Indiana Capital Chronicle that Ritchie reacted sharply as the execution started. He jolted upward, lifting his shoulders and twitching violently for around 3 seconds. He didn't fall back down immediately. It seemed like he slowly settled back and then remained still for a few minutes before the curtains were drawn. Oscar Smith, Tennessee, May 22, 2025. Oscar Franklin Smith was sentenced to death in Tennessee for capital murder, and he was executed after years of delays. Originally set to be executed on April 21, 2022, his execution was temporarily halted by Governor Bill Lee due to issues with the lethal injection protocol. The murders occurred on October 1, 1989, when Smith's estranged wife, Judy Roberts Smith, and her sons, Chad and Jason Burnett, were killed in Nashville. Judy was shot in the neck and stabbed multiple times. Chad was shot in the eye, chest, and torso, and Jason was stabbed in the neck and abdomen. A sharp tool called an awl was found at the scene, but the murder weapons, a .22 caliber revolver and a knife, were never recovered. At the time, Smith and Judy were already separated, and Smith had taken out life insurance policies on all 3 victims. The couple had 3-year-old twins. Several co-workers testified that Smith had threatened Judy's life on numerous occasions and expressed resentment towards her sons, allegedly saying she favored them over the twins. During the attack, the family attempted to call 911, and Chad was reportedly heard screaming, "Frank, no." At trial, investigators claimed to have found a bloody palm print matching the 2 missing fingers Smith had. However, Smith later hired an expert who questioned the reliability of that evidence and pointed out errors in the original analysis. Smith was sentenced to death on July 26, 1990. His execution was initially planned for December 3, 1990 by electric chair, but legal appeals delayed it. Over the years, he became part of a broader legal challenge, arguing that lethal injection is cruel and causes extreme suffering. His execution dates in 2020 and 2021 were postponed due to the global context at the time. In 2022, Smith's legal team requested clemency from Governor Lee, seeking a sentence of life without parole. As he had been sentenced before 1999, Smith could choose his method of execution, either the electric chair or lethal injection. He declined to choose, so the state defaulted to lethal injection. In early 2022, Smith attempted to reopen his case based on new DNA evidence found on a weapon, but a Tennessee court denied his motion. Subsequent appeals to the Tennessee Supreme Court were also rejected. Governor Lee initially chose not to intervene, but later he issued a temporary reprieve upon discovering the state had not followed the correct procedures for testing the lethal injection drugs. Specifically, they had not been tested for endotoxins. This led to a suspension of all executions in Tennessee for the rest of that year and a third-party review of the process. By late 2024, the state had implemented a revised lethal injection protocol using pentobarbital. In March 2025, a new death warrant was signed for Smith, setting his execution for May 22 the same year. As he once again refused to choose a method, the state proceeded with lethal injection. Smith was executed as planned. He was pronounced dead at 10:47 a.m., and in his final statement, he maintained his innocence, saying, "Someone needs to tell the governor the justice system doesn't work. I didn't kill her." For his last meal, he requested hot dogs, tater tots, and apple pie with vanilla ice cream. After the execution, Judy's siblings expressed ongoing grief and emphasized the lasting pain of domestic violence, a tragedy shared by many other families. Smith was the 19th person executed by the U.S. this year. For the month of June, 5 inmates have active death warrants. On June 10, Anthony Wainwright in Florida and Gregory Hunt in Alabama. Then on June 12, John Hanson in Oklahoma. The next day, June 13, Stephen Stanko in South Carolina. And on June 25, Richard Gerald Jordan in Mississippi. June was a chilling month on death row. From last meals to final words, these are the people that were executed and the crimes that put them there. Gregory Hunt, June 10, Alabama. On August 2, 1988, Karen Lane was brutally murdered in the apartment she shared with Tina Gilliland, located at 105 Elliott Heights in Cordova, Alabama. Lane had been dating Gregory Hunt, Gilliland's cousin, for approximately 1 month prior to her death. On the afternoon of August 1, 1988, Hunt was at the apartment with Lane when Gilliland's ex-husband arrived with his fiancée, Shirley Romine, to pick up his and Gilliland's 2 children. Gilliland was taking a nap at the time. According to Romine, after Lane left the room, Hunt expressed frustration, stating he was tired of everything and planned to move back to Miami, Florida. He also said, "She makes me so mad I could kill that bitch." When Gilliland woke up around 6 p.m., Hunt was gone. Shortly after, Gilliland and Lane left in Gilliland's beige 1986 Yugo. After stopping to buy cigarettes, they went to the residence of Gilliland's then-fiancé, Clinton Cook, in Parrish, Alabama. Upon arrival, around 7 p.m., they saw Hunt's van outside. Gilliland entered the residence while Len left in the Yugo. Inside, Hunt noticed Lane in the Yugo and asked Gilliland why Lane didn't get out of the car. Gilliland replied that Lane had gone to her mother's home. Hunt then left. Later that evening, Hunt visited the home of James Molinex and Hortensia Ovalle in Jasper, Alabama, arriving around 8 or 8:30 p.m. While there, Hunt discussed his frustration with Lane, stating he needed to do something about the problem. As he left, he said he was going to f somebody up. Returning to Cordova, Hunt called Cook's residence around 9:40 p.m. from his mother's home at 405 2nd Street. He asked Gilliland where Lane was. Gilliland told him Lane said she was going to her mother's home. Hunt warned, "I know how you women are. You better tell me where she's at." When Gilliland replied she didn't know, Hunt insisted, "You better tell me where she's at or it is going to be detrimental to you." He added he was ready to go back to prison if necessary. Later that night, Lane's father, W.O. Sanders, discovered that a house Lane had previously occupied was on fire. Sanders, who lived about 200 yards from that house, testified he heard Hunt's van pass his house twice that night. After the second pass, he discovered the fire. After calling Gilliland and driving by Sanders' house, Hunt returned to Jasper. When Deborah Twilley returned home from work at 11 p.m., Hunt was there using her telephone. Twilley noted Hunt appeared to have been drinking. He asked to borrow her car, explaining, "I've got some stuff I need to do. It's not wise that I'm seen in my van." After Twilley refused, the conversation turned to Lane. Hunt said he was tired of her and admitted to burning her house, stating he poured gas on it and set it on fire. He asked Willie to drive him to Cordova to check if the house had burned down completely, expressing hope that it had. Around midnight or 12:30 a.m. on August 2, Amy Cherie Long saw Hunt in his van chasing Lane, who was driving the beige Yugo at high speed in Cordova. Hunt then returned to his mother's home and called Cook's residence at 12:55 a.m., speaking with Cook. Hunt said something had happened materially and that Karen's family and Karen would be upset with him because of what he had done. He stated he would have to move back to Florida, but added people didn't screw him over like this and get away with it. Around 1 a.m., Hunt called Lane's mother, Betty Jo Sanders, asking if Karen was there. When Sanders said no, Hunt mentioned Karen's house had burned and that she would be hurt because she loved that place. He also said he had been looking for Karen, stating she was running stop signs and lights, and all he wanted to do was say hi to her, but she wouldn't stop. Hunt also threatened violence against Gilliland, saying, "You know, Tina is scum. I'm going to throw her up against the wall, do you know what I mean? I won't do to mess with. I grew up in violence. I know what it's all about." Shortly before 2 a.m., Mary Turner, who lived at 103 Elliott Heights, in an apartment separated from Gilliland's by one other apartment, heard a noise that sounded like glass breaking. She saw Hunt reach his hand into the window of Gilliland's apartment and then enter through the adjacent door. After Hunt entered, Turner heard peculiar noises, one that sounded like somebody had hit the floor hard and another like someone sliding a chair across the floor. Around 2 a.m., she heard the door slam and saw Hunt leaving the apartment. At 2:44 a.m., Cook received another call from Hunt, who was calling from Gilliland's apartment. Hunt told him that Karen was lying there in the kitchen floor and asked Cook to get somebody up there to get her to the hospital. Karen Lane's body was discovered in Gilliland's apartment later that morning. After calling Cook, Hunt returned to Jasper. Molinax and Ovalle testified they found Hunt's van outside their home around 6 a.m. According to Molinax, Hunt was in the van and, as Molinax left for work, he raised up a little bit and then went back down. Later that day, Hunt drove to Cullman, Alabama, to Jack and Jean Kilpatrick's house. From there, around 7 or 8 p.m., Hunt called his brother-in-law, Russell Davenport, in Cooper City, Florida. Hunt said he had been out partying with a woman and got into a fight with her. He stated, "I don't think I killed her. I'm not sure how she was when I left her. I checked with the hospitals and newspapers, and I can't find anything else about her at all." Hunt was arrested later that month. In October, his sister, Loretta Martin, visited him in jail. Martin testified they discussed Karen Lane's death. During their conversation, she asked Hunt, "You did kill her?" Hunt said, "Yes, I did." He explained they had a fight on the night of her death. He hit her, lost his head, and couldn't control himself. Hunt told Martin he had gone out looking for Lane and chased her through Cordova. When Martin asked if he had been drinking, he said he had been drinking and taking some medication prescribed by a doctor. In June 1990, while detained in jail pending trial, Hunt also confessed to his cellmate James Carr Sanders. Sanders testified Hunt said he and Lane had fought because she was dating someone else. He had knocked her down, choked her, kicked her, and inserted a broomstick into her private area. After that, he saw she was bleeding, became scared, and called the police. Dr. Joseph Embry, who performed the autopsy, testified Lane sustained approximately 60 injuries, including about 20 to the head. Her injuries included lacerations, external bruises, bruises to the brain, fractured cheekbones, nasal bones broken into small pieces, 12 rib fractures on each side, a fractured breastbone, bruises to her heart and lungs, a bruised pancreas, a 3/4-inch tear in her aorta, and 3 tears in her liver. She also had bleeding in the muscles in her neck and numerous bruises and lacerations on her arms, legs, chest, and back. Larry Hughes, a serologist with the Alabama Department of Forensic Sciences, analyzed swabs from Lane's private parts and mouth. The oral swabs revealed Lane's mouth contained genetic material. Hughes stated that quantity and condition of the material suggested that it was deposited very close to the time of the death, if not post-mortem. Gregory Hunt, 65, was pronounced dead at 6:26 p.m. at a South Alabama prison on June 10. He was executed by nitrogen hypoxia. An inmate is forced to breathe pure nitrogen gas throughout the execution process, depriving them of oxygen, which is essential for survival. Hunt, strapped to a gurney and wearing a blue-rimmed mask that covered his face, did not offer any last words, but seemed to use his fingers to make the thumbs up and peace signs. It was unclear exactly when the gas started to flow, but it started after 5:55 p.m. At 5:57 p.m., Hunt jerked, gasped, and lifted his head off the gurney for a moment. At approximately 5:59 p.m., he moaned and raised his legs. After 6:05 p.m., he stopped moving and took 4 or more gasping breaths with extended intervals in between. The gasps and trembling motions were similar to earlier nitrogen executions in Alabama. Critics claim that although the state maintains that the motions are expected, they demonstrate that the execution procedure does not guarantee a speedy death. A number of Lane's family members were present at the execution. Hunt was one of the death row inmates in Alabama with the longest sentence. Last month, he told the media that he wanted to help other prisoners and that discovering religion in prison helped him become free of his demons. Since 1998, he has been teaching a weekly Bible class. Hunt refused his final dinner tray, which included hot dogs, vegetables, potatoes, and black-eyed peas. However, earlier that day, he was served a lunch tray containing bologna, black-eyed peas, carrots, and fruit punch. On the same day, but in another state, another inmate faced his death. Anthony Floyd Wainwright, June 10, Florida. On April 27, 1994, Carmen Gayhart, a 23-year-old nursing student and mother of 2 children, was abducted in Lake City, Florida. Born on September 2, 1970, Gayhart had been working towards her nursing degree while also raising her young children. That day, she vanished without a trace, setting off a series of events that would later shock the state. The individuals responsible for her disappearance were Anthony Floyd Wainwright, born October 22, 1970, and Richard Eugene Hamilton, born February 16, 1963. Just a few days before the crime, both men had managed to escape from a prison facility in North Carolina. Carmen was declared missing when she failed to arrive at her children's daycare to pick them up, something that was extremely out of character for her. At the time, she was attending nursing classes at Lake City Community College and was last observed in a parking lot not far from campus earlier that day. Her failure to collect her kids immediately raised alarm among her loved ones. Her husband, her father, and classmates began a frantic search for her, but when their efforts yielded no leads, she was officially reported missing. Unbeknownst to them, Carmen had already been abducted at gunpoint by Wainwright and Hamilton. She had just finished loading groceries into the Ford Bronco she had been driving in the parking lot of a Winn-Dixie store when the 2 escapees targeted her. Just 2 days prior to this horrifying incident, Wainwright and Hamilton had broken out of a minimum security facility in Carteret County, North Carolina. Wainwright had been serving a 10-year sentence for burglary, while Hamilton was serving a 25-year term for armed robbery. After their escape, they stole a vehicle and broke into a home where they obtained 2 rifles. Armed and on the run, the men fled southward into Florida, where they ultimately encountered and abducted Carmen Gayhart. After capturing her, the 2 men ditched their original stolen vehicle at a lumber yard along U.S. Route 41. They then took off in Carmen's Ford Bronco with her still alive in their custody. They transported her to a secluded forested area located behind the Fuel City truck stop off State Route 6 in Hamilton County, Florida. Hidden away from view in a remote and isolated location, they subjected her to a violent and degrading essay. According to Richard Hamilton's later testimony, Wainwright attempted to strangle Carmen following the assault. To ensure she was dead, Wainwright then shot her twice in the head using a bolt-action .22 caliber rifle, killing the young mother. After leaving her body in the woods, the pair fled, continuing their attempt to escape capture. During court proceedings, each man accused the other of being the one who strangled and shot Carmen. The next day, on April 28, 1994, the 2 fugitives were located in the vicinity of Brookhaven, Mississippi. When approached by a state trooper from the Mississippi High Patrol, Wainwright and Hamilton opened fire, resulting in a shootout. Both suspects were wounded but survived their injuries. Hamilton was shot in the face, while Wainwright sustained a gunshot wound elsewhere. At the time of their arrest, they were still driving the Ford Bronco that had belonged to Carmen Gayhart. However, despite recovering the vehicle, authorities had yet to find any trace of Carmen herself. Following his arrest, Hamilton waived his right to contest extradition and was quickly returned to Columbia County, Florida. Once back in Florida, he underwent an extensive interrogation by detectives from the Columbia County Sheriff's Office regarding Carmen's disappearance. During this interrogation, Hamilton confessed to the crime and offered detailed information about what had occurred. He even went so far as to sketch a map identifying the location where they had taken Carmen, essayed her, attempted to strangle her, and ultimately shot her. However, despite drawing the map, Hamilton was unable to specify the exact city or county where the crime took place. In his statement, he admitted that both he and Wainwright had taken part in the essay, but claimed that Wainwright alone had committed the actual murder by shooting Carmen. On May 2, 1994, Tina Wheeler, a dispatcher with the Hamilton County Sheriff's Office, recognized the area depicted on Hamilton's map as being near State Route 6. Acting on this tip, Deputy Sheriff Mel Black and Albert Jones traveled to the identified area around 4:30 in the morning to search for Carmen's body. During their search, Jones noticed a strong foul odor and notified the investigators. As the sun rose at around 7 a.m., authorities discovered Carmen's decomposing remains. The case was officially taken over by the Hamilton County Sheriff's Office, and her body was sent to the District 4 Medical Examiner's Office in Jacksonville for further analysis. After the body was transported, a more detailed search of the crime scene was conducted. Dr. Margarita Arruza, the medical examiner overseeing the case, observed that several of Carmen's teeth and her hyoid bone were missing. Based on her findings, she advised law enforcement to revisit the crime scene. Following this recommendation, investigators returned and were successful in recovering some of the missing teeth as well as the hyoid bone, critical in corroborating evidence of strangulation. In the weeks following their arrest, both Wainwright and Hamilton were formally charged with a series of serious felonies, including first-degree murder, sexual battery, robbery, and kidnapping. In July 1994, a grand jury indicted both men on all counts. The state attorney for Florida's 3rd Judicial Circuit, Jerry Blair, announced that the state would pursue the death penalty, citing the particularly brutal and premeditated nature of the crimes, along with the aggravating circumstances such as the essay, kidnapping, and Carmen's vulnerability. The case drew substantial public interest as the horrifying nature of the crimes generated widespread outrage. Carmen's family made it known that they supported the pursuit of capital punishment for both men. Due to the extensive media coverage and difficulty in assembling an impartial jury in Hamilton County, the court opted to move the trial to Clay County, where a jury was more easily seated. While they were held at the Clay County jail awaiting trial, both Hamilton and Wainwright repeatedly expressed a desire to escape. Authorities received intelligence indicating that the pair was actively plotting a breakout that allegedly included a plan to murder a correctional officer during their attempt. Given the seriousness of these threats, both men were moved to maximum security cells, and additional precautions were taken. During court appearances, stun belts were fitted to both inmates and kept activated to ensure control and prevent any violent outbursts or escape attempts. The separate trials for both men began in May 1995. On May 30 of that year, both juries returned guilty verdicts against Hamilton and Wainwright for the kidnapping, essay, and murder of Carmen Gayhart. Just 2 days later, on June 1, 1995, both juries recommended the death penalty. The jury in Wainwright's case was unanimous in their decision, while Hamilton's jury returned a 10-2 majority in favor of execution. On June 12, 1995, Circuit Judge Vernon Douglas sentenced both men to death in the electric chair. In addition to their death sentences, the judge handed down 3 consecutive life terms each for the additional crimes committed against Carmen. Hamilton's direct appeal to the Florida Supreme Court was rejected on October 23, 1997. His second appeal, filed in 2004, was also denied. On March 3, 2017, his petition to a writ of habeas corpus was rejected, and on February 8, 2018, his final post-conviction appeal was turned down, confirming his death sentence. Wainwright's direct appeal was similarly dismissed by the Florida Supreme Court on November 13, 1997. His subsequent appeal in 2004 was also denied. On November 13, 2007, the U.S. Court of Appeals for the 11th Circuit rejected his case, and in 2008, the Florida Supreme Court dismissed the third appeal. Most recently, in July 2023, the 11th Circuit again rejected Wainwright's latest appeal, which included new DNA evidence. The court ruled that the DNA findings did not effectively counter the trial evidence or demonstrate Wainwright's innocence. On January 13, 2023, Richard Hamilton died at the age of 59 while incarcerated at Union Correctional Institution in Florida. He had spent roughly 28 years on death row. The Florida Department of Corrections did not release a cause of death. Following his passing, Wainwright remained the sole surviving perpetrator of the 1994 crime. On May 10, 2025, Florida Governor Ron DeSantis signed Wainwright's death warrant, setting the execution date for June 10, 2025. Anthony Wainwright, 54, received a lethal injection at Florida State Prison. Around 6:10 p.m., the execution got underway. At 6:14 p.m., Wainwright's shoulders trembled a few times, and he blinked and inhaled deeply before going motionless. Gayhart's husband, son, and mother-in-law were among the 17 family members who witnessed Wainwright's death at 6:22 p.m. Wainwright did make a final statement, but it was inaudible from the witness room. On the morning of his execution, he was offered a special last meal, but he politely declined, opting only for the regular prison breakfast. 2 days later, John Hanson was executed in Oklahoma. On the evening of August 31, 1999, a horrifying sequence of violent crimes unfolded in Tulsa County, Oklahoma. Two men, George John Hanson, also known by the alias John Fitzgerald Hanson, and Victor Cornell Miller, embarked on a crime spree that included the carjacking and the brutal murder of a 77-year-old woman, as well as the cold-blooded killing of a man who had the misfortune of witnessing their criminal activity. That same evening, Mary Agnes Bowles, a 77-year-old retired banker from Tulsa who had once served as president of the St. Francis Hospital Auxiliary, became a victim of Hanson and Miller. She had been at the parking lot of the Tulsa Promenade Mall when the two men abducted her. Earlier that day, the duo had already committed 2 liquor store robberies and were actively looking to expand their crime spree. They targeted Bowles specifically for her vehicle, intending to use it to carry out additional robberies. During the abduction, Miller took control of the driver's seat while Hanson held Bowles at gunpoint in the back seat as they drove away from the mall. Their journey took them to a dirt pit near the town of Owasso, a location owned by Gerald Max Thurman, a 44-year-old businessman who operated a trucking company in the area. By coincidence, Thurman was on site making a delivery when he noticed a suspicious vehicle, Bowles' car, repeatedly circling the pit. Concerned, he made a phone call to his nephew to report what he had observed. Tragically, moments after the call, he encountered the man. In an attempt to eliminate him as a witness, Miller approached Thurman and shot him 4 times with a revolver, leaving him critically wounded. While this was happening, the pair continued on with Bowles in the car. Eventually, they pulled over at a roadside location. There, Hanson forced Bowles out of the vehicle and mercilessly shot her multiple times, between 4 and 6, using a semi-automatic handgun. She was killed instantly. After the murder, Hanson and Miller tried to conceal her body by covering it with branches before fleeing the area. Thurman's shooting did not go unnoticed. Nearby individuals who heard the gunshots alerted authorities, leading them to discover Thurman's location shortly after the incident. Although he was still alive when found and rushed to a hospital, he succumbed to his injuries 2 weeks later, on September 14, 1999. Bowles, on the other hand, was not discovered until a week after her abduction. Her body was found on September 7, 1999. In the days that followed, law enforcement launched an intensive investigation. On September 9, 1999, Hanson and Miller were arrested at a local motel. Their arrest was initially for a separate crime, a robbery committed the day prior, on September 8, at a federal credit union. As police continued to investigate, they soon linked the two men to the murders of both Bowles and Thurman. Forensic analysis revealed their fingerprints on Bowles' vehicle, and investigators discovered a revolver, along with a 9mm semi-automatic pistol wrapped in plastic hidden inside the vehicle's gas tank. These were identified as the weapons used in the killings. The evidence led to formal charges against both men for the murders. Additionally, Hanson and Miller faced multiple federal robbery charges for crimes committed before and after the murders. George Hanson stood trial first. His criminal history included prior convictions dating from 1983 to 1990 for robbery and assault. In May 2001, he was tried separately for the first-degree murders of Gerald Thurman and Mary Bowles. After a nearly 5-hour deliberation, a jury in Tulsa County found him guilty of both murders on May 18, 2001. Prosecutor Tim Harris sought the death penalty in the case. A few days later, on May 23, the jury returned with their sentencing recommendations: the death penalty for Bowles' murder and life imprisonment without the possibility of parole for the murder of Thurman. Despite having received a death sentence, Hansen was not transferred to Oklahoma's death row. Instead, due to his involvement in separate federal robbery cases, he remained in federal custody. He was ultimately sentenced to life in prison for the federal charges and was housed at the United States Penitentiary in Pollock, Louisiana. Victor Miller, Hansen's accomplice, was tried separately following Hansen's trial. Miller had a violent criminal past as well. In 1981, he had been convicted of first-degree murder in another case and received a life sentence, along with 3 30-year terms for armed robbery, which were to be served concurrently. That earlier conviction was later reduced to second-degree murder, and Miller was released in 1997, just 2 years before the Bowles-Thurman murders. Like Hansen, he also faced federal charges for unrelated robberies and was sentenced to life in federal prison. He was then extradited back to Oklahoma to stand trial for the double homicide. On April 17, 2002, a separate Tulsa County jury found Miller guilty of both murders. 2 days later, on April 19, he was sentenced to death for Mary Bowles' murder and life without the possibility of parole for Gerald Thurman's. George Hansen's legal journey continued. On June 11, 2003, the Oklahoma Court of Criminal Appeals overturned his death sentence and ordered a resentencing trial. That new sentencing phase took place from January 9 to January 24, 2006, and once again, Hansen received the death penalty for the murder of Bowles. In April 2009, his appeal was dismissed. Appeals to higher courts followed, all of which were denied. The U.S. District Court for the Northern District of Oklahoma rejected his appeal in July 2013, the 10th Circuit Court of Appeals denied it on August 13, 2015, and the U.S. Supreme Court followed suit on May 16, 2016. Even as recently as September 10, 2021, another appeal was rejected. Hansen was one of 28 Oklahoma death row inmates who filed a lawsuit challenging the constitutionality of the state's execution procedures. However, in June 2022, the lawsuit was dismissed when the court ruled that Oklahoma's execution protocols did not violate constitutional protections. Meanwhile, Victor Miller pursued his own appeals. In 2004, the Oklahoma Court of Criminal Appeals overturned his convictions and sentences, granting him a new trial. That retrial took place in November 2008, during which he was again convicted on both counts of first-degree murder. This time, the jury recommended 2 death sentences. On December 9, 2008, Judge Dana Keown formally imposed both death sentences. However, Miller's legal saga did not end there. In 2013, the Oklahoma Court of Criminal Appeals heard his appeal and determined that one of his death sentences should be commuted to life without parole, while the other sentence should be overturned and subjected to another resentencing hearing. By November 2015, before the resentencing trial could proceed, Tulsa County prosecutors announced they would no longer pursue the death penalty in his case. As a result, Miller was handed a second life sentence without parole. As of 2025, he remains incarcerated at the Oklahoma State Reformatory. As Hansen exhausted all of his appeals by 2016, he remained on federal death row at USP Pollock. A 2020 report indicated he was one of 26 inmates in Oklahoma eligible for execution, having no remaining legal challenges. However, at that time, executions in the state were paused due to a series of mishandled executions, including a botched one in 2014 and 2 serious drug mix-ups in 2015. The state resumed executions in October 2021. On July 1, 2022, the Oklahoma Court of Criminal Appeals set execution dates for 25 death row inmates whose appeals had been exhausted. George Hansen's execution was initially scheduled for December 15, 2022, with a clemency hearing set for November 9 of the same year. Oklahoma officials requested the federal government to transfer Hansen to Oklahoma's custody to carry out the execution, but the request was denied. It was believed that this refusal may have been influenced by the Biden administration's moratorium on federal executions, although no official reason was confirmed. Subsequently, Oklahoma Attorney General John O'Connor filed a lawsuit against the Federal Bureau of Prisons for refusing to hand over Hansen. On December 13, 2022, U.S. District Judge Reed O'Connor ruled against the state, stating that the Bureau of Prisons had broad discretion in matters involving public interest and that the federal government could decline to authorize a transfer. As a result, Hanson's execution was indefinitely postponed. After Donald Trump was inaugurated as U.S. President on January 20, 2025, Oklahoma Attorney General Getner Drummond promptly reapplied for Hanson's transfer on January 23. The move was backed by an executive order signed by Trump directing the Department of Justice to resume capital punishment enforcement. Drummond criticized the prior administration's decision, calling it the epitome of subverting and obstructing the execution of a capital sentence. On February 13, 2025, newly appointed U.S. Attorney General Pam Bondi approved the request, allowing Hanson's transfer to proceed. By March 3, 2025, Hanson was moved to the Oklahoma State Penitentiary, the designated facility for housing death row inmates. On April 1, 2025, the Oklahoma Court of Criminal Appeals set his execution date for June 12, 2025. In the wake of this announcement, Jake Thurman, the son of Gerald Thurman, spoke publicly about the emotional weight of the long wait. He expressed a mix of relief and sorrow, stating that justice was finally being served after nearly 3 decades. He described his father as his hero and friend, adding that his children bore a strong resemblance to their grandfather, which kept his memory alive. Jake also shared how devastated he and his mother were when Hanson's execution was stayed in 2022. Tragically, his mother passed away less than 2 months later due to organ failure. Though he expressed disappointment that Miller had not received the death penalty, Jake also said he had made peace and forgiven both men. A clemency hearing was held for George Hanson on May 7, 2025. His legal team appealed for a commutation of his sentence to life without parole. Oklahoma Attorney General Drummond, however, strongly opposed any form of clemency. He urged the Pardon and Parole Board to reject the plea, stating, "This murderer's execution has been delayed for far too long. I am committed to ensuring that the Bowles family finally sees that justice is done for their loved one." On May 7, 2025, the Oklahoma Pardon and Parole Board, in a narrow 3-2 vote, officially denied the request for clemency. At 10:11 a.m., John Fitzgerald Hanson, 61, was declared dead after receiving a lethal injection of 3 drugs at the Oklahoma State Penitentiary in McAlester. At 10:01 a.m., the execution got underway. At 10:06 a.m., the doctor entered the execution chamber and declared him unconscious after the deadly medicines started to flow. Hanson could be heard snoring when the Department of Corrections Chief of Operations announced he was unconscious. For his final meal, he didn't ask for anything special. He did receive the same meals as the other prisoners: carrots, 2 rolls, 2 fruit cups, and chicken pot pie. His last words were, "Just forgive me. Peace to everyone." Stephen Stanko, June 13, South Carolina. Stephen Christopher Stanko, born on January 13, 1968, at the Guantanamo Bay Naval Base in Cuba, was convicted for a brutal series of crimes committed in 2005, which included the cold-blooded murders of 2 individuals, as well as the kidnapping and essay of a teenage girl, the daughter of one of his murder victims. Stanko's criminal background predates these murders. In 1996, he was incarcerated after being convicted of assault and kidnapping. He served 8.5 years of a 10-year sentence before being released from prison in 2004. During his time behind bars, he co-authored a book titled Living in Prison, A History of the Correctional System with an Insider's View. This work was written during his first prison stint and offered both a historical and personal account of the correctional system in the U.S. Upon release, Stanko was described by those who encountered him as an articulate, intelligent, and well-spoken former inmate. He appeared to be a reformed man who was open about his criminal past and often discussed the time he spent in prison, as well as the book he had written. He moved to Myrtle Beach, South Carolina, shortly after being released and rented a room where he stayed for nearly a year. His parole officer took measures to ensure transparency and confirmed that the landlady was aware of Stanko's criminal background, something Stanko himself disclosed when applying for the room. During this period, he kept a low profile. Although occasionally late with rent payments, he caused no significant trouble. He frequently lamented the difficulties he faced in securing stable employment due to his criminal record. Over the course of the year, he held 1 or 2 short-term jobs, though none lasted. Eventually, he vacated the rental property abruptly and moved in with a friend, offering to look after her elderly mother in exchange for room and board. Roughly 1 year after his release from prison, Stanko began spending time at a local library under the pretense of conducting research for a second book. It was during this time that he became acquainted with Laura Ling, a librarian who worked there. Their relationship grew, and eventually, Stanko moved in with Ling as her romantic partner. He also struck up what appeared to be a friendly rapport with another regular library patron, 74-year-old Henry Turner. However, beneath the surface of this seemingly stable post-prison life, Stanko was preparing for a spree of violence that would shock the community. In April 2005, he carried out a series of horrific acts. He strangled 43-year-old Laura Ling to death, shot Henry Lee Turner in a fatal attack, and then essayed and violently attacked Ling's teenage daughter by slitting her throat. Miraculously, the young girl survived her injuries and managed to place a 911 call that would lead to the unraveling of Stanko's crimes. Following a highly publicized trial where his defense team attempted to argue insanity, Stanko was convicted on multiple counts. On August 18, 2006, a jury in Georgetown County found him guilty of the murder of Laura Ling and sentenced him to death. In addition, he received a prison sentence of 110 years for the related crimes committed against Ling's daughter, included criminal sexual conduct, kidnapping, and armed robbery. In a separate trial in November 2009, related to the murder of Henry Turner, Stanko was again found guilty. This time, a jury in Horry County handed down a second death sentence. When law enforcement officers searched his residence, they discovered numerous articles and materials about infamous serial killers such as Jeffrey Dahmer and Gary Ridgway, the so-called Green River Killer. This led police to speculate that Stanko had either a strong interest in serial killers or was potentially attempting to become one himself. Following the brutal attacks, a nationwide manhunt ensued. A reward of $10,000 was offered for any information leading to Stanko's capture. Thanks to tips from the public, he was eventually located and apprehended without incident by the U.S. Marshals Service in Augusta, Georgia. At the time, Stanko had been hiding in the Augusta area, blending in during the annual Masters tournament, which attracts large crowds, making it easier for him to remain inconspicuous. Stanko's appeals process began on September 23, 2007, when he made his first appearance before the South Carolina Supreme Court. His legal team aimed to overturn the death penalty verdict he received for the murder of Laura Ling. They argued that the original trial had been flawed, claiming the trial judge had improperly barred the defense from questioning prospective jurors about their views on the insanity defense. Moreover, they contended that the court did not permit them to present evidence about Stanko's age or mental state as mitigating or aggravating factors. Despite these arguments, the South Carolina Supreme Court ultimately upheld both the conviction and the sentence. Years later, in February 2013, Stanko suffered another legal defeat when the South Carolina Supreme Court affirmed his conviction and death sentence in the case of Henry Turner's murder. Following this, in 2015, Stanko sought post-conviction relief through another legal process known as a PCR hearing. During this proceeding, his former trial attorney, Bill Diggs, testified that Stanko suffered from a brain defect that may have influenced his behavior. Despite this testimony, on May 24, 2016, the court upheld the conviction and denied Stanko any form of relief. Stanko's final hope rested with the highest court in the country. However, on May 5, 2025, the United States Supreme Court denied his petition. According to 15th Circuit Solicitor Jimmy A. Richardson II, this denial meant that all legal appeals related to the murder of Henry Turner had been exhausted. As a result, the South Carolina Supreme Court was authorized to issue an execution notice. Execution notices in South Carolina are typically issued on Fridays in accordance with state procedures. This scheduling method ensures that the execution is carried out on the fourth Friday after the notice is issued, allowing adequate time for any last-minute legal interventions. In Stanko's case, the official notice of execution was issued on Friday, May 16, 2025, the first Friday available following the May 5th court decision. The preceding Friday, May 9, had been a state holiday, Confederate Memorial Day, during which the Supreme Court was closed. The execution of Stephen Stanko had been scheduled for June 13, 2025. He was given until May 30 to choose the method of his execution. Under current South Carolina law, death row inmates are permitted to select between three methods: electrocution, lethal injection, or a firing squad. Reacting to the long-awaited execution notice, the son of Henry Lee Turner expressed a sense of resolution. He publicly stated that he intended to be present for the execution and remarked that, in his opinion, it should have taken place many years ago. He remembered his father fondly, describing him as a cheerful, kind-hearted individual who was a loving and devoted parent. In the days following the announcement of his execution date, Stanko submitted a formal request to the state seeking more information regarding its protocols for both lethal injection and execution by firing squad. He initially indicated a preference for the firing squad. However, after reading published details about the recent execution of inmate Mikal Mahdi, he reconsidered. Ultimately, the South Carolina Supreme Court rejected his request for more information on May 29, 2025. On June 13, Stephen Stanko, 57, was pronounced dead at 6:34 p.m. Following a farewell statement that lasted 3.5 minutes, during which Stanko apologized to his victims and requested that they not judge him based on the worst days of his life, the execution got underway. In contrast to earlier executions, witnesses could hear prison officials requesting the first dose of the sedative pentobarbital. Stanko seemed to be speaking as he turned to face the victims' families and then quickly exhaled as his lips trembled. After a minute, Stanko seemed to stop breathing. The color drained from his cheeks and hands and his vibrant complexion vanished in an instant. 13 minutes later, a prison staff member requested a second dose of pentobarbital. About 28 minutes after the execution began, he was declared dead. Until long after Stanko's respiration ceased, 3 of the victims' relatives continued to stare at him. Stanko's lawyer and brother also observed. For his last meal, he chose fried fish, fried shrimp, crab cakes, a baked potato, carrots, fried okra, cherry pie, banana pudding, and sweet tea. His final words were, "Once I am gone, I hope that Christina, Laura's family, and Henry's family can all forgive me. The execution may help them. Forgiveness will heal them." Thomas Lee Goodinas, June 24, Florida. On the evening of May 23, 1994, Thomas Goodinas, along with 3 of his roommates, made their way to Barbella's bar located in Orlando, Florida. They arrived sometime between 8:30 and 9 p.m. Before reaching the bar, the group had already consumed alcohol and Mary Jane, drinking beer and smoking both at their shared apartment and again inside the car during their drive to the bar. Their substance use didn't stop there. Throughout the night, as they continued drinking, the group would periodically step outside to their vehicle to smoke some more Mary Jane. By the time the bar closed at 3 a.m., Goodinas was missing. One of his roommates later testified that the last time he saw him was around 1 a.m., but after that point, no one in the group knew where he had gone. That same night, Rochelle Smith and her fiancé also visited Barbella's, arriving between 11 and 11:30 p.m. After enjoying their time there, they decided to leave at approximately 2 a.m. However, Smith mistakenly walked to the wrong parking lot. It was there that she noticed a man crouched behind another vehicle, observing her. This man was later identified as Thomas Goodinas. Realizing her mistake, Smith walked over to the correct parking lot where her car was actually located, but she couldn't shake the feeling that someone was following her. Acting on instinct, she quickly got into her car and locked all the doors. Her fears were confirmed when the same man she had seen earlier suddenly approached her car. First, he tried to open the passenger side door. When that failed, he attempted to smash the driver's side window while shouting at her in a threatening and sexually aggressive manner, reportedly yelling, "I want to f*** you." Smith began sounding her car horn in a panic, which eventually caused Goodinas to flee the scene. Later on, she positively identified him from a police photo lineup as the man who had tried to assault her that night. The night took an even darker turn. Michelle McGrath was last seen alive at Barbella's at about 2:45 a.m. Like Smith, McGrath had parked in the same lot where Goodinas had been lurking earlier. Tragically, her body was discovered the next morning, on May 24, 1994, by an employee of Pace School located near the bar. Her lifeless body had been dumped in an alley adjacent to the school. The medical examiner estimated her time of death to be sometime between 3 and 5 a.m., indicating she died shortly after she was last seen. When her body was found, it was completely naked except for her bra, which had been pushed up above her chest. McGrath had suffered multiple severe injuries, including blunt force trauma to the head, and she showed clear signs of having been essayed. The medical team also found trauma to both the cervix and rectum, injuries that were caused by the forced insertion of foreign objects into her body. Additionally, genetic material was discovered both inside her private area and on her thigh, suggesting that sexual violence had occurred either before or after her death. The brutality she experienced was significant, marked by violent trauma, visible bite marks, and the kind of blunt force injury that suggested she had been stomped on. McGrath had been alive and conscious during large parts of the attack. Before the body was discovered, Jane Brand, an employee at Pace School, had noticed a suspicious man within the school's gated premises. When she confronted him and told him he needed to leave, the man quickly jumped over the fence and disappeared into the nearby alley. Curious and concerned, Brand looked into the alley and found McGrath's body. She later identified the man she had encountered on school grounds as none other than Thomas Goodenas. After Barbella's closed and everyone had returned to their apartment, all of Goodenas's roommates testified that he had not come back with them. Later, when they did see him again, they noticed what appeared to be fresh injuries, bloodstains on his underwear and scratches on his knuckles. When questioned about these wounds, Goodenas claimed that he had been in a physical altercation with two black men who had attempted to rob him. However, his story began to unravel. Two of his roommates testified that when asked whether Michelle McGrath had been a good fuck, Goodenas chillingly responded, "I killed her, then I fucked her." Goodenas's violent history extended well beyond this tragic incident. In the early 1990s, during his time as a juvenile, he had already racked up multiple felony convictions in the state of Massachusetts. His criminal record included charges such as burglary of a vehicle, assault, theft, assault with intent to essay, indecent assault and battery, and assault and battery. On Tuesday, June 24, Goodenas, 51 years old, was put to death by lethal injection. At 6:13 p.m., he was declared deceased. Media observers claimed that the sound of an air conditioner interfered with his final statements, making them inaudible. Goodenas uttered a prayer of some kind, according to a prison spokesperson. He had pizza, fries, and soda for his last meal. Richard Gerald Jordan, June 25, Mississippi. Jordan, born on May 25, 1946, was incarcerated on death row in the state of Mississippi, having been convicted for the brutal murder of 34-year-old Edwina Martyr in 1976. Edwina was the wife of Charles Chuck Martyr, a prominent bank executive. From 2022, Jordan held the distinction of being the oldest living inmate on Mississippi's death row, as well as the individual who has spent the longest duration under a death sentence in the state's history. At the time of the crime, Jordan was experiencing a severe financial crisis. Unemployed and facing mounting financial stress, he began contemplating a criminal plan to obtain money through unlawful means. His desperation led him to conceive a scheme in which he would target a wealthy individual, specifically a bank executive, with the intent of extorting ransom money. To carry out his plan, he contacted Gulf National Bank located in Gulfport, Mississippi, posing as someone seeking a commercial loan. Through this ruse, he was able to learn the name of the bank's commercial loan officer, Chuck Martyr. Once he had this information, Jordan located Martyr's residential address using a local telephone directory. He then drove to the residence and abducted Edwina Martyr. Tragically, instead of keeping her alive for ransom purposes, Jordan transported her to the DeSoto National Forest and fatally shot her. Following this, he called Chuck Martyr in an attempt to extort ransom money by falsely claiming that Edwina was still alive. Initially, Jordan was found guilty in 1976 and sentenced to death. However, that verdict and the corresponding death sentence were later overturned due to a landmark decision that deemed automatic death sentences unconstitutional. Jordan was retried in 1977 and once again convicted and sentenced to death. He later appealed this second sentence, raising constitutional objections, and as a result, he was again sentenced to death following another trial. When the third death sentence was also overturned on appeal, prosecutors offered Jordan a plea agreement. According to the terms of this deal, he would plead guilty in exchange for a sentence of life imprisonment without the possibility of parole, and in doing so, he would waive all future rights to appeal. Jordan accepted the terms of this plea bargain, but he subsequently violated the agreement by filing an appeal against his sentence. In his appeal, he argued that a sentence of life without parole was unconstitutional in his specific case because, at the time of the crime in 1976, Mississippi law did not provide for such a sentencing option. Instead, he sought to have his sentence reduced to life with the possibility of parole, which was an available punishment under Mississippi's sentencing laws at the time of his offense. While the courts ultimately found the original plea agreement to be invalid, they did not grant his request for parole eligibility. Instead, a new sentencing hearing was ordered. This hearing took place in 1998, and at the conclusion of that proceeding, Jordan was again sentenced to death. Richard Jordan was born in Hattiesburg, Mississippi, to Mr. and Mrs. Homer Jordan. He spent his childhood in the nearby town of Petal, Mississippi. People who knew him during his youth and school years would later describe him as someone with a generally good reputation. After completing his education at Petal High School, Jordan enlisted in the U.S. Army, where he served for a period of 4 to 5 years, including active duty during the Vietnam War. By the mid-1970s, Jordan was married and the father of 3 children. Following his honorable discharge from military service, he found employment in Louisiana, while his wife and children remained in Hattiesburg. Jordan managed a fertilizer plant for about a year and also worked for a couple of months at a shipyard in Morgan City, Louisiana. By January of 1976, Jordan found himself in a state of dire financial distress. Faced with multiple debts and unable to make ends meet, he devised a desperate plan to kidnap a member of a wealthy family and demand ransom in exchange for their safe return. With this goal in mind, he set his sights on Gulfport, Mississippi, as the location where he would carry out his plan. On his way out of Louisiana, Jordan stopped at a pawn shop located at Baton Rouge, where he traded in his 16-gauge shotgun for a 38 caliber revolver. To his family, he lied, telling them that he was heading out to take a physical examination as part of the application process for a job of an offshore oil rig. Once in Gulfport, Jordan spent a few days familiarizing himself with the city and observing his surroundings. Then he set his plan into motion. On January 12, 1976, Jordan drove to the Martha residence, where he posed as a utility worker from the electric company who needed to inspect the home's circuit breakers. Under this false pretense, he was able to convince Edwina Martyr to allow him access. He then abducted her from the home, leaving behind the couple's 3-year-old child, who was asleep inside. At the time of the abduction, Chuck Martyr was away at work and the couple's older son, who was 9 years old, was attending catechism class. After kidnapping Edwina, Jordan forced her to drive with him into the remote and heavily wooded DeSoto National Forest. At some point after exiting the vehicle, he shot her once in the head, killing her. Jordan claimed that he only fired his weapon after Edwina attempted to flee and that he had meant to fire a warning shot above her head. In contrast, the prosecution argued that the evidence, including forensic analysis, indicated that Edwina had been kneeling and was shot at close range. Following the murder, Jordan went to a local movie theater where he watched the film Death Wish, a vigilante crime drama. Afterwards, he contacted Chuck Martyr and demanded a ransom of $50,000, falsely asserting that Edwina was still alive. Later that evening, the two men spoke again and agreed on a specific location for the ransom drop. That night, Chuck Martyr went to the designated site with law enforcement officers discreetly following him. Jordan, who was observing the location from a distance in the DeSoto National Forest, immediately detected the police presence and suspected a setup. The next day, he called Martyr again, accused him of trying to trick him, and offered an alternative ransom plan, this time demanding only $25,000. He instructed Martyr to take a convoluted route to the drop site, making numerous turns before getting on the highway to shake off any possible police surveillance. On the morning of January 13, at approximately 9 a.m., Martyr left the cache at a predetermined location near the intersection of Interstate 10 and Canal Road in Gulfport. An FBI agent and a deputy from the Harrison County Sheriff's Office were stationed nearby, concealed in a pickup truck, waiting to apprehend Jordan. When Jordan arrived to retrieve the money, the officers sprang into action. Jordan rammed the sheriff's vehicle into a ditch and sped away, ignoring gunfire directed at his car. One of the deputies involved in this failed apprehension attempt was Larkin Smith, who would later rise to political prominence, serving as both the Harrison County Sheriff and eventually a U.S. congressman. Despite initially escaping the authorities and abandoning his car, Jordan was eventually located. Around 1 p.m. that same day, a Gulfport police officer spotted him inside the taxi. He was arrested without further incident, and the majority of the ransom money was recovered. During police questioning, Jordan confessed to having murdered Edwina and led authorities to both her body and the murder weapon. During a subsequent psychiatric evaluation, Jordan told a mental health professional he had not acted alone, that an accomplice had actually shot Edwina and fled the scene before Jordan attempted the ransom scheme. However, this account was inconsistent with earlier statements, and Jordan's defense team ultimately chose not to use it in court due to concerns over its reliability. In July 1976, Jordan stood trial for the crimes of kidnapping and capital murder. Due to the extensive media coverage and concerns about finding an unbiased jury in Harrison County, a change of venue was granted and the trial was moved to Jackson County. It took place in Pascagoula, with jury selection beginning on July 19. The trial lasted 3 days. The prosecution presented a total of 24 witnesses, while the defense chose not to call any. After 4 hours of deliberation, the jury returned a guilty verdict for capital murder on July 21. When asked by the judge whether he had anything to say before sentencing, Jordan declined to speak. At the time, Mississippi law mandated an automatic death sentence for capital murder convictions, and that was the sentence Jordan received. However, a case was already pending before the Mississippi Supreme Court that was widely expected to declare such automatic sentences unconstitutional. Anticipating this legal shift, District Attorney Albert Case and Assistant District Attorney Joe Sam Owen considered requesting a separate sentencing hearing, but found no legal basis under state law to support such a motion. That same year, the U.S. Supreme Court ruled that automatic death sentences did indeed violate the Eighth Amendment's prohibition against cruel and unusual punishment. As a result, Jordan was granted a new trial. His second trial began on February 28, 1977, again in Pascagoula. This time, the trial was bifurcated, with separate proceedings for determining guilt and, if necessary, sentencing. Jordan was once again convicted of murder on March 2, 1977. The sentencing phase took place on the same day. Defense attorney Earl Denham addressed the jury, stating that Jordan had been a good and decent man until around the age of 30, at which point something inexplicable changed in him. Denham described Jordan as mentally ill and incapable of understanding his actions. The defense presented several character witnesses, including Jordan's parents and a prison chaplain who had spent over a year praying with Jordan. The prosecution cross-examined the chaplain but called no new witnesses of their own. During deliberations, one juror initially opposed the death penalty. Denham and co-counsel Rhett Russell requested a mistrial, but the judge denied the motion. Eventually, the jury unanimously agreed to impose a death sentence. In the early 1980s, Jordan's attorneys challenged his sentence on the grounds that the jury had not received adequate instructions regarding how to determine whether aggravating circumstances applied. During closing arguments, Prosecutor Owen had told jurors that they had to individually decide what constituted an aggravating circumstance, without offering clear legal definitions. In 1982, the Fifth Circuit Court of Appeals ruled that the jury had not been properly instructed, citing a need for objective standards. The court overturned Jordan's sentence and ordered a new sentencing hearing. In the spring of 1983, shortly before this hearing, Denham withdrew from the case. Joseph Hudson, a Gulfport attorney, was appointed to represent Jordan, assisted by Earl Stegall. Although Owen had since moved into private practice, he agreed to serve as a special prosecutor for the hearing at the Martyr family's request. Jordan testified that he had been financially overwhelmed and desperate, owing money for a car, a boat, and several department store credit accounts. His defense team called witnesses to vouch for his character, including prison guards and family members. The prosecution presented forensic evidence suggesting Edwina was stationary when she was shot. They also introduced a recording of Jordan admitting that he had formulated the ransom plot before seeking legitimate employment. Once again, Jordan was sentenced to death. He would later challenge this third death sentence on the grounds that he was denied the opportunity to introduce mitigating evidence, specifically testimony from Rhett Russell about Jordan's good behavior in prison and the creative invention he had worked on involving wind tunnel-generated electricity. The Mississippi Supreme Court rejected this appeal, ruling the testimony to be inadmissible hearsay. However, the U.S. Supreme Court disagreed, reversed the sentence, and remanded the case for a new hearing. In 1991, prosecutors offered Jordan a plea deal to avoid a fourth sentencing trial. He would receive life without parole if he agreed never to challenge the sentence again. Jordan accepted. However, the resolution would not hold. Years later, Jordan filed a federal habeas corpus petition in which he challenged the legality of his sentence. He argued that life without parole was not a lawful sentence at the time of his crime in 1976 and therefore could not be applied retroactively to him. The federal court agreed, finding that the sentence was indeed unconstitutional in his case. Although the court did not grant Jordan's request to be resentenced to life with parole, it did vacate the sentence and return the case to the state for another resentencing. At this point, Mississippi prosecutors, frustrated by the repeated appeals and reversals, decided to pursue the death penalty once more. Jordan's legal team accused the state of prosecutorial vindictiveness, essentially punishing him for exercising his legal right to challenge his sentence. They contended that the prosecution had only sought the death penalty again as retaliation for Jordan's appeal in violation of his constitutional rights. The courts, however, ultimately ruled that there was no clear evidence of prosecutorial vindictiveness and allowed the state to proceed with seeking the death penalty. In April 1998, Jordan faced his fourth sentencing hearing. The trial was held in Harrison County. This time, the jury was given clear and constitutionally sound instructions regarding aggravating and mitigating circumstances. After considering the evidence, the jury returned yet another death sentence. Since that time, Jordan remained on Mississippi's death row, where he continued to pursue various legal appeals. He challenged both the constitutionality of his death sentence and the state's method of execution. One of his most recent and significant claims involved Mississippi's lethal injection protocol. Jordan's attorneys argued that the state's current execution method, which includes the use of midazolam, a sedative that has been the subject of multiple legal controversies, could result in severe pain and suffering, thus violating the Eighth Amendment's prohibition on cruel and unusual punishment. In addition to challenging the method of execution, Jordan repeatedly raised the issue of prosecutorial vindictiveness. Despite these arguments, the courts have consistently ruled against him. In 2022, Jordan became the oldest and longest-serving death row inmate in Mississippi. His case has been cited frequently by legal scholars and capital punishment critics as an example of the flaws and inconsistencies in the American death penalty system. Over nearly 5 decades, Jordan has been sentenced to death 4 separate times and has spent almost 50 years navigating the legal system. On June 25, he was executed by lethal injection. His last words were, "First, I would like to thank everyone for a humane way of doing this. I want to apologize to the victim's family. I will see you on the other side, all of you." Jordan was served his final meal of chicken tenders, French fries, strawberry ice cream, and a root beer float at 4 p.m. local time. Please hit that subscribe button if you like my channel. See you next time. Bye bye.